50?
Yes. With the consent from the petitioner's side. Kindly pass over the letter.
In any case, I don't think
Yes.
we'll get time to hear it. They'll come after vacation.
Date may be fixed at after the month of November, my God, 18 November, it may be fixed.
On the pay of the consent 50, I can actually for the day. List after vacation on 18/11/2020.
And deep future.
Let please lordship the item number 70. The matter is in Texas. I
70.
70.
Item number 70 is submitted by the council. That the matter has become in function. Disposed of the code.
That is your lordship. Your lordship, in item number 29, CD is not available. May the matter be action
It is not available.
29. We are in interim or interim section only.
29. CD not received. Issue reminder. Interim bill stands extended. Huh? Take it up.
Then,
No, need to.
moreover, your lordship, with regards to item number 13, your lordship, it's an
One.
1-3. It's an admission matter. May it be taken before the court.
Take it up.
Admission matter may be taken before this.
Okay.
Matter.
You can go in normal course.
May I please your lordship, which my document, item number 16 lordship,
16.
some difficult questions. Kindly put the question also.
Oh, is there is missing. Fifth.
Item number 5. I connected with same case.
It's a fact. You can do it.
Yes.
Let us take up.
16 is adjourned.
So 16 is not a job. We'll take it up when the matter comes up and then take it.
May I please, with regards to item number 28, my lord, CD has not received. We are on interim.
28.
28. If you post it,
28 case diary not received.
we are,
Interim bills are continue. The next step is. Fix one. When should I can you suggest a date? We start.
Either interim lordship.
We started the edition on
22nd.
22nd,
In
22,
in month.
22/10. This was item number
28.
28.
Either interim
Uh-huh.
and it's for month also.
August.
22/10.
May I please your lordship? This case, my lord, earlier one of this one, instead before this on the court, scan copies was called for, but today I want to submit, my lord, subject your lordship permission. At this stage, my lord, the court can consider my case on the basis of facts and circumstances of this case. On that point, subject to lordship permission, I want to submit your lines.
Wait.
My lord, in
Just
this
a-
case,
just a minute.
this under trial case, my lord,
Just a minute, before proceeding, just to refresh myself. The scan copy is not received.
can come out, my lord.
So we called it 22, so it's not received.
My lord.
And this informant has been,
No notice not issued on that day. I was submitted before this honorable court. At this stage, FOXO note attracted against person. And according to my submission, honorable court notice was not issued to the informant.
let us go. Tell me,
My lord.
you all have to go a little quick today. So that we can finish
Well,
all the matters.
My lord, in this
Page
case,
number, I should.
yes, my lord, this is PW1, page 48, evidence of the informant, my lord, victim's father. In this case, two witnesses are already examined. One is informant, another is victim herself. And by these two witnesses, my lord, if we go through the contents of the evidence of the PW1, there is no whisper about FOXO. I want to read out again, my lord.
Order, Lordship. And thereafter, Lordship, subsequently charge sheet was submitted and accordingly, Lordship, my bail was continued. But Lordship, as Lordship became my livelihood, Lordship, I went to Itanagar, Lordship, for doing some work under a mason lordship. And I fall from four-story building lordship, and thereafter due to some head injury lordship, I could not able to appear before the court below. And subsequently lordship, after recovery lordship, on 12/8/2025, I appeared. But I was taken into custody lordship, thereafter lordship. Now I am able to appear lordship.
Charge on the workshop.
So the petitioner, some contender is right to destroy the public vehicle as well as the police vehicle. Being agreed, the police authority has lodged an FIR. Accordingly, FIR has been registered by this two PS case number 2725 under section 132, 324, 3, 117 subclause 2, 296, 329, 4, 3, within letter B of BNS Act and reduced section prevention of damage of public property Act 1984. So only 117 punishment, supposed to is the punishment 7 years, and under 3 of the prevention of damage of public property Act 1984, that is up to 5 years punishment. In this case, your lordship kindly be pleased forwarding letter annex B page number 15, wherein the petitioner was arrested on just 9 years back, almost 9 years back, that is on 12/9/2025. Only because of that, the patrolling, the police personnel has went roaming in that area, had seen that the number of the transgender has roaming from here to there. Only because of that, the petitioner has been arrested. The question is that your lordship, that is under Article 19, clause 1A, every person has the right to free movement. So, being a democratical country like India, so people are moving here and there, so they did not announce. Moreover, more interestingly, your lordship, that is the compliance provision, statutory provision, as per the BNS Act under section 35, subclause 3, the notice ought to have been given to the accused or to inquiry,
They were,
but no procedural.
they were arrested during the incident.
No, just after 9 years back. Very interesting.
9 years.
Sorry, 9 months back. After 9 months back, when they have seen, police have seen that some transgender has moving here and there. Only because of that, the petitioner has
So
been
9 months.
9 months. 9 months. So at the time of place of occurrence, they were not red-handed. Event of that clearly mentioned
Anyway,
that. So,
False for the case there.
so your lordship, kindly, your lordship, events of that lordship, under compliance provision 47 of the BNSS, even the Supreme Court Honest Kumar judgment and the recent judgment, no ground of arrest has been communicated to the
So that
accused.
we don't know, no? We have to see.
Your lordship,
Mr. Saikat.
yeah, your lordship.
But also, all for the case diary of dispute case number 27 of 2025. Accused persons, 3 in number, the 3 accused persons herein were arrested on 12/9/2025. It's pointed out that the fire was lost on 15/1/2025. Anyway, I'll give you in the vacation. Huh? Eight
Yeah,
day. Take a chance. We'll take a chance, huh? Okay.
Your lordship.
EMS are yes.
Today's event protest with the earlier rejected. The person on the length of the internet, the petitioner, so I, the petition, running 9 months. Is necessary.
Yeah, she's pregnant for 8 months,
9 months running.
9 months. About to
Delivery is present, let's send the medical documents with and accept all this conditional.
show me the medical document.
It's 22.
Insurance. Initial couple of months. Four months. Anyway. This Boroma PS is available, I think, is there is available.
Earlier rejected.
Yes, yes, fair enough. It was rejected on 15/9. Updated case diary there is to. Then you try to get this. Just calculate, huh? We are males, 23 weeks will be. 4 weeks. 4 months. 5 months. Yes.
Which is this regular bail application also will find a at page square 11. Portion at page 19 also. The allegation of theft of dog selling. It is 19.
Two petitions are here.
16 is there on interim. Interim.
16. Elect.
Oh,
This is BA.
yeah, both
BA
are
for 4 people.
4 people. Next one's invoke lordship 109 lordship and 303
Which is the FIR.
FR page 19 lordship 19.
Sixteen is this for case diary. The
Yeah.
case diary come in this case. Some 16 goes connected. Case diary is available. You can kindly assist. Stray dogs.
State of allegation is involvement in theft of state of person. And section 109 is also involved person. Might not be.
109.
Attempt to murder, that might not be,
Not really.
not really.
And that is animal cruelty. Other law would be there.
Other law, animal, 96,
Homicide.
loss. And 303 is theft, 20 days lordship. From the date of forwarding.
This matter we can taken up along with 16.
Yeah, I have taken up the 16.
Yes, along with.
I have taken up together. 16, the 16 is a AB.
City well.
No, they are also here,
VA by law, interim.
interim regular.
Regarding my viewing of stray dogs, my lord, with disputes and thereafter, my lord, we capture and taking. What is the reason for this? 16 of the business.
Yes. 109 cannot come. It's only pertaining to human beings. Again, theft also I see a problem because theft means out of there should be some owner of the property. Yes. Animal, it may be property. I'm not sure about that. But stray dogs are actually they don't belong to anyone. So anyway, what is the investigation reveal?
Investigation regarding earlier you were saying while granting interim bill to the other petitioners, if their statement not yet recorded, then you record their statement again. But here I have found that regarding item number 5 statement of this on the accused person number 16. Their statement is on the basis.
The next number. Is 20. Okay, no, Mr.
MQs.
Second, third. Fourth. Better. Again. Present accused persons were arrested on 4/9/2025 and presently in judicial custody. The case diary is as received and placed before the court. Since the progress of investigation. In the given facts and circumstances, I am of the considered view that the accused persons therein should be granted bail according they are allowed to own bail of this. 15,000 each. So it is like a separate legal commission that they shall cooperate with the investigation. Second, number two, will not hamper and don't give it. We don't like the conditions and disclosure. In this, in the other matter,
James Kamrup M.
she concerned learned decision. In the other matter, your senior, you're them, I can give you a name. Yes? Oh, yes. Which would be right? 998. Okay. The petitions. First. Yeah. If there is progress, place before the debate, like there's the petition, this persons hearing were granted interim bail on 11/9/2025. The given facts and circumstances. I would have considered that this person should be given granted bail, therefore, the interim bail granted rights also paid. It's hereby made access. Same condition. Disposed, allowed and disposed of. Return application. Yesterday, it was discussed on 47 and 48 regarding. There's 59 laws. West 59 is a notice under 47, petition number 1. So there is no grounds of race and nothing has been mentioned this. What you call it. Page 60 is the notice under 47 for the petition number 2. I don't know. 142 is already been endorsed in the discussion. Forty-eight notices, this one. Yeah, those LABP. LABP is the wife of the co-accused secretary. He has already been endorsed. And Abdul Salam. Yeah, those. Page 62 and page 63. The contents are saved with LABP. Could you take instructions? Short time.
submitted on this ground. Same submission should be recorded.
Yes.
Highly advised, yeah.
No, actually, not be fair to dispose it of. Because we should call for case diary. But we can, if I am satisfied regarding prima facie long-term extent, we can consider. Because of the principles laid down. So now you can suggest should we get the original case diary? Charge sheet. Has been charge sheet. Charge sheet.
Yeah,
CCR, has it been charge sheet?
please search it in.
Charge sheet. No need, but you can, the scan copy of the CD, the CD in original, this will be heavier. Heavy CD. It's CD. Because CD, this cases, these agencies, they have voluminous CD. So we can call for the case diary and charge sheet, scan copy of charge sheet. And case diary should I call original or scan copy?
Scan.
Scan copy. Sorry, no, because. Sorry, okay. Yes, sorry, yes. Spread of seven, spread of seven. But yeah. And they can learn it. Also preparing for the prosecution slash NCB.
Very good.
I'm seeing your submissions. Other case. Yeah, this is it's much of a submission. And, opposing the bail, opposing the bail. Submits that the records may be prepared. Issue resolution for procuring the scan copy of case diary and the charge from the court of the land additional session was number 5.
Yes.
So, number 5. And what? However, copies of the notices, the 47, 48. 48 is also there. Yes, yes. With regard to the present accused. Have been annexed. The is the same. It appears that crime receipt do not comply with the stipulations of such notices laid down in Vihan Kumar versus full section. It is also submitted that the present petition stands on the same footing as co-accused Chaketun was granted bail by this court on 17/9/25 on such procedural information. It has been laid out in Vihan Kumar to that non-compliance with these mandatory procedural provisions be violative of Article 22(1) the Constitution and make the arrest make the arrest illegal and further detention untenable. It has also been held that the right to bail in such a situation would prevail over any statutory restriction. Accordingly, in the opposite facts and circumstances. In the interim, accused points of no accused person. No accused person. Where is the notice with regard to the other person? Page 62 and page 63. So I checked only one. Or listen, page 50, sorry, no, page 59 and page 60. Noor Safi and Sarif Session. Page 60. Yes. Relative of this thing is Noor Safi is Abdul Salam. Yes, right? And relative of this is Abdul Salam. Okay, that's fine. No. In the both the accused persons here, namely, we have allowed to go on bail of rupees. I had given 1 lakh in that person. 75,000 each, security of the light amount each. And subject to the following conditions. In case of violation. In case of violation of bail condition, the interim bail is liable to be cancelled. This stop, when should we fix for extra bail here on? After petition. Last of October. 2310. Is it? Yeah.
Your Lordship, anticipatory bail application, FIR is at page number 9.
Motion.
FIR at page number 9. May I read the FIR?
Six two. Six. You see. 6 and 19. 7. Go ahead, page number.
Page number 9, Your Lordship. May I read the FIR, Your Lordship? Sir, it is most humbly submitted that the above mentioned accused person, by making various promises, has made my sister elope with him. The accused person is a married person and has 4 children. When we were unable to find our sister, we called the accused person multiple times, but still he did not pick up the phone. Thus, it is humbly prayed that proper investigation will be done to recover my sister and take necessary action against the accused person. Lordship, the girl has already returned to her family. It's a matter of emotional love and relationship matter.
15-year-old.
Indeed, Your Lordship, but she has already returned back to her family. POXO is not attracted in the case. Your Lordship. POXO
there-
sections are not valid.
Use the FIR dated 11/8/2020. All for the case diary of
Murajar PS case.
Muraja case number
140.
145 of 2025. The section 87. Yes. This
14,000. 14, much of it.
Report was postponed. Report has come.
The case against him, my lord, case is registered, my lord, Sabgam PS case number 158/2025. And there are several cases in different police stations against him. He's a member of the organized crime.
Report is come.
Yes,
Written report. Can I have them? This application hurts and such. The petitioner filed this bail application apprehending arrest, though they did not have details of the case with regard to him in Satgaon police station. The report was called for. Pursuant to which is this report? Which one?
Last page.
Sargaon PSK. Report is received. Pursuant to which report dated 25/9/25 is received. Very stated that Sargaon PS case number 158/2025 is registered therein under section 303 within bracket 2/318 BNS. Accordingly, call for the case diary of Sargaon PS case number. The report may be kept in this file, in the case file. This is the whole of the report. Your copy is also there. Only the report will be, but your copy is also there. Only the report will be there. List after the vacation on. When you want to, when should I fix it? 15th. Right. 15th. 15th.
I did
Same. Your matter?
Yes.
Your matter, yes. Thank you. Correction of guidance. Sargaon institution. So all from Sargaon institution.
Salary.
Report was called for from Salbari police station. Which district? Salbari? Parcel. The district of Parcel. Is submitted by prosecution that report, no report is received. You should remind. Same day. List on 15th. Issue reminder for the list on 15th.
Yes, no. Personal.
Report was called for from. Verify this is a Patsala station. The district of Madali. Report not yet received. List on 15th. Issue reminder. Yeah.
Made his lordship. Lordship of agency FIR was 13. It's a long FIR lordship.
I can go through myself, or you want to read?
That's true, lordship. 18 petitioners are there, lordship. Lordship has seen the allegation, lordship. How
and
the
complex.
how the fact is exaggerated, lordship. Lordship, we may be protected, lordship. Will APR will cooperate with the investigation, lordship. Till then, lordship. 18 petitioners are there, lordship. Otherwise,
Mention about repeated threatening by AK-47.
the AK that is seen by only the informant. Not there is administration also.
The petitioners are moving around with AK-47 every moment. That is only seen by the informants, Lordship, not by the other administration, Lordship.
Happy to say, Shivaya, but I am submitting some photographs. Photographs with stating everything. The conditions of the victim. are-
Admittedly, I have also stated
Still-
my
still
petition.
they are suffering, Lordship, and still the mother of the victim is admitted in hospital, Lordship.
Lordship, I have stated in my petition, there is quarrel between the informant and the arrested accused person. 5 persons are arrested, Lordship, and they are family members also.
Your good name? AIU Sheikh, Lordship. Learned counsel appears for the, keep this up, but if necessary, if you want to bring on record formally, if later you file an affidavit, it's but now, fails, but can you just, thank you. At least let us see, yeah, call for the. Very serious. Call for the case diary of. Support case number 141 of 2020. Please stop, when should I fix? Then it be on 17. 17.
Lordship,
Along with medical. report.
yes, medical report regarding allegation under section 6 of POCSO Act, Lordship.
Come in the city, along with medical.
Lordship. Obliged.
City may be called. Makes that like stays. All for the case diary of Gauripur PS case number 377 of 2025. This 21. After application 15 or 14 10.
Right, you should, we should create as bail application. Lordship will find the FIR at page 11. Your FIR was lodged in the year 2016, minor. Incidents are of
2016.
minor, and
Okay.
incidents are of 13 and 2015.
Yeah.
Minor.
Any quick, submit?
Minor. So far as my petitioner is concerned, my lord, allegations are in page number 12, my lord. Lordship will kindly turn to page 12, my lord. Serial number 2, my lord. That we have, my lord, that we have received another complaint from one customer, namely so and so, through our dispute branch claiming 13 lakhs, it is alleged by proprietor so and so, that we have given check bearing number so and so dated 39/2015 for rupees so and so to Ranji Hazarika, SW dispute branch, husband of Mrs. Jumidas. Now she is in the Lubari branch of the bank, and her husband Ranji was working in the dispute branch. And in collusion, they diverted all this money at our Ulubari branch, for which the slip was prepared by Jumidas without any authorization from the customer. Instead of opening fixed deposit, ADR amount in the name of customer, the check amount of 13 lakh was transferred fraudulently to the following two different accounts. Now my account is, my lord, serial number 2, CBS Business Associates. He used to do supply work, and this Ranjiv Hazarika, my lord, with all respect, he is a next door neighbor of this petitioner. And on bona fide billing, my lord, I used to leave some signed checks to him so that he can, with all respect, my lord, prepare brain drafts so that I can participate in tender process. And when this amount was given to Ranjiv Hazarika, he fraudulently transferred
the same 6.5 lakhs to my account and 6.5 lakhs to the other account, my lord. Now, the account being a CC account, my lord, the passbook was not given in such accounts, my lord, and I was unaware that money was transferred to my account. Now, this Ranjit informed me that in the meantime, he was placed under suspension because of this anomaly, my lord. He said that some account has been transferred to my account, which belongs to him. And accordingly, by way of a signed check, my lord, he withdrew them. Now, from 16 onwards, nothing happened, my lord. All of a sudden, my lord, Lordship will kind of place with all respect, my lord, 14. This notice under 41 has been issued against me. And I was asked to appear on 16/9/25. Accordingly, I appeared, my lord. And Lordship will try to place 15, my lord. Now, they have again called me on 7/10/2025. Page 15, my lord. Hence, you were requested to appear before me on 11 M 7/10/2025. Now, I am ready to cooperate, man. My mainstay was not there, apparently and palpably, because wife and husband did everything, my lord. So I may be protected because 7/10 I have again been called, and there is a rider, my lord, down below the notice. Failure to attend comply with terms of this notice can render you liable for arrest.
Yes, once the person complies.
My lord. But my lord, the rider is this, my lord.
But this matter, pending, it's pending. I think which date it is pending does. Now, we have to call the CD in any case.
My lord.
Already disposed. They are disposed of. CD is gone back now. Allowed.
Sumitas will be PA, my lord, and Ronji would be, my lord, anticipated.
Ronjit. Name actually.
Yes. Will be PA, my lord.
No case there is no.
Lordship will definitely call for the case there.
So I was asking, if any date is already fixed for that,
Mine.
then we can fix it on the
True,
same.
my true. Earlier 41/8/3 is now 35/5.
Yeah, so
Mine.
they have to give specific reasons.
Mine.
You cannot be arrested otherwise.
Till the arrival of the diary, my lord, can I be protected? I am ready to cooperate. I will again appear on 17th. Kindly, my, with all respected for them. If something comes up in the city, not to be definitely reject my prayer.
That's learned counsel. There is for the petition. Which allegation as a fire. The learned counsel submits that not not connected with the alleged offences indicated in the FIR pursuant to notice under 41A. We have appeared earlier, but again called to appear
On 17th.
on 17 and due to which is apprehending arrest.
Mine.
Call for the case there.
CAD, please.
CID case number 1 of 2016.
Mine.
So the learned counsel pays for interim protection. Apprehending that we may be arrested on the subsequent appearance. In case of appearance of the petitioner. In terms, in compliance with the notice. The due process of law stipulated in 41A shall be followed by the. However, I intend to pass an interim order of bail at this stage, explaining the nature of the allegation. All for the it's on when we want, but it's on vacation. We want it in the vacation. I'm not getting interim, but an observation is made.
13 already open.
Tell them 30.
30. My apprehension is this one. For reason,
No, I'm interim, I'm not granting, but I've made an observation that if he appears you have to follow the compliance because indirectly it is minus. He has to follow that compliance, that mine. He has to give special reasons if he wants to arrest him. Hopefully. Yeah, that. Two admission matters. Team, right? Yes. Criminal revision. Report was small. Yes. Jigma matters. Yes. Currency. Jigma was regarding a phone launch. Lots of phone. Yes. On page 20 is the Caesar list. Phone has been taken in custody for 5 months now. Launching. And it's so it is required to be exhibited from my experience. The vehicles and all, it's easy to, but electronic items, if they're made material objects, they are properly sealed and all, but the stuff is done. Sometimes it becomes difficult to open it again. Sometimes it's just general experience I have. But I'm not an apprentice of people, and I was just being there. True. And 17 is the forwarding. What is the Interim order? Realme that mobile, no? Yes, Realme. Interim order is on page 12. We require, so at this stage it was an investigation.
Well, otherwise I have received the report, as per the report order. Now I'd like to state that these article of Nurul Islam can be given. No, that's all. Can be given in general report.
Again, disposal of it.
Yes. This report may continue to kept as a part of.
Actually, see, at that time it was justified in evidence. So criminal revision, I have to actually see this order. Yes. In criminal petition, I have wider flexibility. Strictly speaking, I cannot go beyond this order in a criminal revision. Right. In a criminal petition, which is you as you know, this is more bit like read criminal witness. So there, you can also go a little take note of subsequent events. Still, procedurally slightly erroneous, like expositor. But I'll not delay expositor. Next time this kind of matters, it's better to file a review petition or just add the section read with 558 now. Gives you the flexibility. But if you add that section also, a nomenclature will be criminal petition. Criminal petition. Oh, you have added also. You have added. Otherwise, they are registered on the criminal revision. You have added. Then gone by the 5 sections. Right, you have right here. The petitioner hearing, namely Nurul Islam, has filed the instant petition invoking the powers stored under section 438/442/528 DNS. Seeking interim custody / Jimma of a electronic item within bracket Realme 11 Pro bearing IME IME 1. I'm done. Prayer for interim custody made before the learned session just was rejected by the order dated this on the ground that it was required for further investigation as contended by the IO in the report. In the meantime, an updated report was called for and the same is received, submitted by the learned additional PPP portal. It is contained in it is stated in the report that investigation is over or not going on.
Oh, my lord, regarding investigation is going on regarding filing of such statement, nothing else.
Nothing.
Such statement.
Okay. It is stated in the updated report dated 25/9/2025 that at this stage, the interim custody of the said mobile phone can be given to the petitioner upon showing proper documents. At the stage of investigation, not much quarrel, there's not much cannot be said that there was any information in the order of the learned session judge rejecting the prayer as the material was stated to be material object stated to be required for investigation. However, in view of the subsequent developments indicated in the updated report, the prayer of the petitioner can be allowed by invoking the powers, inherent powers under 528 CRPS. According the same material object within bracket mobile phone make real be bracket close shall be given to the petition, who in turn shall submit necessary documents regarding the ownership and subject to the condition that shall be produced for the trial court if it is necessary. The report shall be kept in the custody. Revision stands allowed and disposed of negotiations. Short cycle. Short cycle.
Maybe it's a lordship. Lordship in this case, lordship. Lordship, there is respondent number 2, lordship, is appeared. But my learned friend on a
This is also a revision, right?
division, lordship. He's not, today is not available. He already informed morning, lordship. The matter
Some
is,
order also.
yes, lordship, matter relating, lordship. The
Defense
patient,
witness.
yes, lordship. Court below, lordship, so far law is concerned, lordship. Court below has some one step. If one step did not follow, lordship. What lordship, law is saying, lordship, after completing the PWs, the matter will be heard on the, and the statement of the defense else may be recorded. Then, lordship, the court below, it, they may acquit it. Thereafter, if not,
230.
yes, yes, yes. If not, lordship, then come to defense. But that step has not been followed in this case, lordship.
Let me see the impute.
Lordship, impugn order is
This is,
seven.
your private respondent.
He is already appeared, lordship. He already informed in morning, lordship, that he is not available today. That's why he already told me that this matter may be fixed after vacation.
Vacation. Excellent. Very recently, if I check it, last week the decision has come. Splitting through. I have not read it at that time. Well, I think last week one decision has come on defense with this. Right?
Yes, 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 lord.
I will be able to tell you the best name. But yeah, that's the legal portion that.
Yes, yes. It's a right, lordship. That right cannot be
If you
cut.
want to address,
Yes,
then it has to be.
yes, lordship.
But suppose you are taking 7 days for that, then it can be closed.
That nothing, that step has not been, that opportunity has not given, lordship, in this case.
What interim order is there?
Lordship, interim order is there, lordship, that is,
Further proceedings.
yes, lordship. 12, 11,
Let us continue.
yes,
The learned, your good name is.
I have, lordship. I have.
I, learned counsel. Yes, for the petitioner. I was the counsel for the respondent. Not available today. Well, post the matter after vacation on 21 to 14.
Last part of the October news.
Yeah, no problem. I was thinking of earlier. It's not late for no problem. Last part of October. Maybe on 30 October. I will try this month.
Yes.
If there is no other complication.
Yes, sir. I'll.
In my scan copy of PCR was called for the copy of the scenes.
Earlier, dated 17 9 2025. 24 9 police 103 different. Is that right? He's in custody since 10/6. 108 days. 10/6. Is it a theft case? Dacoity. See, there's the trial. Immediately after vacation. Scan the PCR. Actually, we need the charge sheet and CD. The vacation. Scan report. Vacation code you want? 9. I can fix it, but I don't.
But it also urgent.
Yeah, usually it's for
108
urgent.
days.
Because everything will come now. The read, everything, civil, everything. For urgent matters. Only for urgent matters.
108 days.
That's true. That was, since it's a case of alleged dacoity, that's why I'm saying it was lighter than. Anyway, just wait for a few days. Scan report not yet received. Issue reminder for scan. Case diary and charge sheet. Trial is not started. It started not. Trial started not. And copies of depositions you can. This is the matter on. It can be on 13 or 14. Yes, 14. The accused person is stated to be detention plus 108 days. For my reference, I'm just. But as a fixed on.
Or my lord, since Burma PS case number 6, yesterday city already taken back. City is not available.
No, because this case, actually the bails have not so far rejected. So this have to go to the case area.
Rejected twice.
Wait, this one.
Twice, yes. This
And that's okay, but that case
one.
22.
So up this.
Developing situation.
That case 22.
That's true, but I think it's not 9 months, if I'm not mistaken. You can guide me. 23 weeks won't be 9 months. 4 weeks. So 16. Yeah, advance. Interim is also, just wait. What for the case that, formal case number. The very serious matter actually. 61 of 2025. The learned counsel points out, referring to the annex documents, that the wife of the present accused is 23 weeks pregnant. This strong. It's my priority basis. Vacation
Today's 73 days nothing. On 9.
Investigation that put the. 13. Urgent matters.
My lord, in this case, petition is behind bars since 37 days, my lord.
No, we had just taken a chance to. Sorry, not.
CP receipt, my lord. Medical report not available. Other eyewitnesses statement, well, other eyewitnesses implicated. But injured person's statement is also not available.
Considering the length of detention and the procedural lapse of arrest, my God, I think we go on by. So far as
What is the allegation?
allegation against it, during a quarrel between two persons, he has attacked with a rod to the from the big change. That is the only allegation. Actual fact is that there was some monetary transaction when he has gone to collect his previous borrowing money, and then a quarrel took place, which is reflected in the FIR itself. And thereafter, the incident occurred. Considering length of detention, if anything, maybe in a test lab. And procedural lapse is there, with regard to arrest, no grounds of arrest have been communicated.
Will you next anything?
No matter.
Grounds of arrest can be seen.
Ah.
That is.
I can,
It should be available in case area. I see.
There's 72 grounds of arrest.
that was,
Investigation could have been an order, actually. Victim statement is also not there. Yes. Its medical report is also not there. 48 notice. 47 notices there. No.
it's very recent.
Future trouble. A ball and the bottom. Stop. Witness seeking regular bail in connection with Mukalmoa. Case 209 of 25 under section 7. He was arrested on this act. The allegation in the Azahar is about assaulting the husband of the informant, causing injuries. If there is received, but it is submitted by learned additional PP that the statement is not available. Statement of victim as well as the medical report not available. The learned counsel placing for the court a copy of notice on the 48 BNSS comes that there is no compliance. There is no compliance. Said notice was addressed to wife of the accused. And prima facie does not satisfy the stipulation. Vis-a-vis, the law laid down in Bihan Kumar. The case diary may be sent back and procured again, updated investigation, including statement and medical report of the victim. However, in the meantime, in the interim, the accused person is allowed to go on bail of 25,000 once yearly, subject to the satisfaction of the concerned knowledge. CDM Nalbari, yes. The satisfaction of the concerned knowledge and subject to the condition that he shall not hamper or tamper with evidence and cooperate with the investigation or not harass or harm the informed. Should I keep this? Yes. If you want, if you don't have copy, you take it back. Yes. But it's better to keep it. Let this matter come up again.
Regarding issuance of section 47 notice, the person to the earlier order of the trial court. Accused person has stated that he knows the grounds and she has received a copy of notice of the section.
Both are necessary. Both are necessary nowadays. Both are necessary. So anyway, it's the old style format. Earlier style. Same thing actually, replica of 47 has to be given to us.
The grounds are communicated to the concerned court below where the accused persons are produced, but not to the informant,
just to
as well as our director.
all those things are more or less clear. Next, is the matter. Since some interim, the investigation progress at 2910. Yes, 29.
Please, Your Lordship. Earlier it was rejected by your lordship. And lordship also perused the case that in the
Page
rejection.
10.
Page 1821.
Serious injuries are there.
Yes. Injury report received.
Uh-huh.
Injury report received.
What's all this was rejected. My medical report was perused in the earlier petition. Indicates piercing injuries and followed by surgical.
Yes.
I have to use my
Yes.
language. Surgical repairs.
Victim statement, victim also. There was some business.
Well, that is also very serious. What
The senseless ones.
is the, see, kindly see the materials after 10:9, especially.
Lordship, representing me with only the length of detention, lordship, that is my prayer now.
That's okay. No problem. 15 days.
Lordship.
It's 90 days of it's not it. 90 days, 90 days.
One more of the, say on 70, because of the same.
It's fairly submitted by the learned council. That an earlier bill petition was rejected on 10/9/2020. And copy also annexed. And it was further submitted that in this subsequent petition file seeking bail based mainly on length of detention.
Finally,
This, so what it goes in this.
regarding collection.
Only for collection.
Medical report already received, final medical report. Earlier, my lord, that was the final medical report.
Was not the final.
Yes, confirm. First portion.
He has implicated. The earlier.
First portion. Big side.
Stab injury, left side of rupture of. I'm looking from where. Piercing injury, surgery. Investigation getting completed. Final medical report has been received. Which also reveals serious injuries. Serious injuries. Serious stab injuries, which necessitated surgery and repair. Investigation is not yet complete. Consider no sufficient subsequent grounds to take a different view in this petition, and the same rate stands rejected at pistis. Return back to this investigation.
Not sure.
Very serious injury.
Much obliged, Your Lord. Much obliged.
Yeah, please, Your Lordship. Yeah, the petition was arrested on 8/8/2025. As on date, Lordship, 50 years completed 50 days.
There is no receipt.
There is no.
Charge sheet.
FSL, no. FSL not yet received. Round sugar, 18. Round sugar, 18.
Attempt.
18 million.
109 is there.
18 million case very not received.
Not. My lord, your lordship, my submission would be lordship. I have completed already 50 days, lordship. This is a 60 days offense. On the last occasion, lordship was placed with that.
109.
109, 92.
It is lordship, 109 has two part, my lord. The first
Oh,
part. On the last occasion,
We
lordship,
don't know what can.
lordship, if we peruse the entire FIR, and lordship, for the sake of argument, if we assume that the entire FIR is true, then also lordship, there is no allegation of fraud. Page number 15 is
I
there.
remember I've written also this.
Page number 15, madam.
Is there any collective bill application?
Yes, madam. Lordship
I
was placed with
must have written there.
It's my lord, this affair was lost after 1 month and 12 days.
This is for another case,
This is for another case.
in the same case.
Same case, madam.
Can I keep this?
Madam.
Or- He was arrested on the same day?
No, lordship. Eight
Oh,
was
8.
arrested.
The accused is arrested, was arrested on 8/8/2025. And presently in judicial custody. Then this is the thing, yes, submitted. Submitted. 4 and 5. The CDS, case diary as called for is not yet received. Issue a reminder for the same. However, in the interim, the accused is allowed to go on bail of rupees 25,000 in one suit, like, para 8, 9. It's lost.
It is.
29/10.
29.
Madam.
29/10. Take out another box. Get this. The petition, this one, we did.
May it please your lordship. Here in this case, lordship, this is a case under section 22C, 25 and 29 of NDPS Act. Here, my prayer would be for calling for the records, but along with the record, lordship, one lordship, may I turn to page 57, that is annexure 11.
Yeah.
Uh,
Order.
Last sentence, lordship, may I kindly see, the petitioner submits that the thumb impression is forged by police and accordingly he prayed for forensic examination of the thumb impression. Here, lordship, the father of the petitioner filed an application before the district judge, special judge, that his signature was forged. He is a retired person and he used to put his signature. And thumb impression was forced by the police, and thereafter it is said that 48 notices served on him. And accordingly, the learned session judge, in last paragraph, lordship, may kindly see, there was a direction that the same petition was forwarded to the learned chief judicial magistrate for inquiry, lordship. And that report may kindly be called for, lordship, through the registry. Learned CP may call for the case diary, lordship, and the direction given in this order regarding the status, that registry may be directed to call for a report, lordship.
Report from,
A report from the special judge Karimganj, Sribhumi,
regarding,
regarding the direction given in order dated 2/9/25,
just
lordship.
So complaint case must have been registered.
So as per my
Must have been
instruction,
registered. Treating the petitioner, the petition number 423 as a
yes,
complaint.
that a complaint case, as per my instruction, Lordship, today I have also obtained instruction, and to my instruction, the CR case is not yet registered. Because I am submitting for Lordship, because this is a serious issue. If they have forged the signature in 48 notice, Lordship, that has to be taken seriously, Lordship.
Definitely, definitely. The whole purpose of the thing will not be there.
Yes, that is why, Lordship, I am praying for
Not be done by anyone and especially law enforcement authority.
Lordship. Therefore, I am praying for calling for case diary along with the direct report, status report in the direction given in the order dated 29/25.
Report has to be called from session judge or
Session Judge Sribhumi, that has to be done by the registry,
yeah, from the, you want the report from the session judge.
Session Judge. Yes.
Same information. Yeah, Met Land Council, preparing to this, assisted by
M.A. Chaudhary.
Met Council. Preparing in the court. So what we, what of law we stop. Okay, the accused was arrested, right, the accused Jahangir Alam Chaudhary was arrested on 7/7/25 in connection with Orange's space case number 319 of 25 under section 22C 25/29 of the 22C 25/29 the NDPS Act. Summit Learned Council submits that case diary may be called for. Issue reputation for the case that don't write it. It is my attention is drawn to order dated 2/9/25 past 5. The learned session judge Sribhumi has for within bracket Orange. Order dated 2/9 session. In the instant case, in a petition, within bracket petition number 423 dated 28/7/2025 by Farooq Ahmed Chaudhary, who is stated to be the father of the accused. In the petition, it was stated, it was contended that though he's a literate person, putting his signatures, but in the notice number 48 DNSS, some impression is shown and it is alleged that some impression is forceful. On this contention, the petition was sent to the learned CGM for proper inquiry, treating the same as a complaint. Learned Council submits that along with this CT, a report may also be report may also be called for from the learned court below regarding the status, if any, of the state inquiry. Call for the case diary of this case number. Further, on perusing the state order dated 2/9/2025, I deem it to allow the prayer this in the relevant prayer. I deem it to allow the relevant prayer first. Therefore, the learned session judge is also requested to procure a report, send the report regarding the same and for it pending before the learned CGM straight. Same inquiry if any before the learned CGM. It leads to do the needful. A copy of the order dated 2/9 can also be sent, or this order can also be sent. Yes.
Lordship.
You want to say something?
No, Lordship.
Order, copy of this order, but you will find out. Copy of order dated 2/9/25. Annex 11 can also be sent. For the convenience of the learned court.
In this case, subject notice submitted, so the city has to be called from the police station. Only city.
Yeah, from the police station, investigation. It's the matter after reopening,
Lordship, immediately after reopening, maybe,
13, 14, 15. Which one would you put?
Lordship.
15,
14.
14, 10.
Obliged, Lordship.
What is the other matter of yours?
Other matter is, Lordship, he is arrested on 12/8/2025. As on today, 46 days, and allegation or under section 21B/29 of NDPS Act, Lordship. FIR, your Lordship will find starts from page 19, relevant portion at page 13.
There is come.
Let's see, I don't know, 19 city.
It is come. Could you go to it or should I?
Yes.
Your Lordship, contraband was found from in a policy plastic bag which was kept in the bicycle motorcycle, Lordship, and in the motorcycle 2 persons were there, and it is not stated clearly specifically from whom it was recovered, and quantity is only, Lordship, 5.56 gram of heroin, Lordship. And forwarding report also says, Lordship, that it may be for selling and also for consuming also. 2 persons were there. Considering the length of detention, I am praying before your Lordship that he may be released on bail. And in the forwarding report, antecedent of other person is there, but regarding this present petitioner, no antecedent is there.
Rahul,
See?
5.56 grams of heroin without vials. 5.56 grams without vials and 7.9 grams over.
intermediate one.
Yes. FSL report not yet received, and regarding my lord criminal antecedent, yes, regarding the present petitioner, from the case diary, there is no such criminal antecedent I have found. But regarding other co-accused,
No, he is not here. Only one person is one person. Rahul, and saying in that aspect you have seen. You will anticipate the different cases. Another aspect, can we see whether there's element of peddling or just consumption? That would be very important.
element of peddling.
Peddling is that.
So,
No, in the forwarding report, ground number 1, Lordship, may kindly see page 17.
Forwarding report is very initial stuff, but it is relevant.
But it is written that in course of investigation, it has been learned. So,
Right,
is
mechanically also.
finding.
Which ground?
Ground number 1.
Sale as well. He is written.
Consume.
Can I have a look?
yes.
Consumption has to be rehabilitated. Peddling is a big problem.
Lord.
My experience, most small time consumers are also small time peddlers. That is how they take out their finance to buy drugs. Fortunately.
Here, one thing is that police during the forwarding report, nor in the FIR, specifically mentioned from whom, whose possession it was recovered. Because 29 is also there. If 29 is there, they have to state specifically what in what manner he has abated. That part is also missing.
Abating or conspiracy is also there. Abating.
Yes, that there has to be
Vicarious liability actually. Anyway, that will come later.
Lordship.
Pending only for FSL.
Yes.
Mostly.
Already 46 days in custody and during vacation, Lordship, that mandatory period will be over. So considering the length of detention and no previous antecedent, I am praying for releasing him on bail, Lordship.
The Nanak Council submits to the, that's all. Considering their length of detention. Will be a statutory period of 60 days, applicable hearing. The bail of the petitioner will be considered. Case diary has been received. On a petitioner people submits that there are materials against the present petitioner. The investigation has progressed and appears to be pending for FSL reporting. I perused the case that seen the relevant materials, in statements of witnesses, the inventory documents. Chapter. They are also submitted by the lawyer additional people that investigation so far has not indicated previous criminal accidents for the present petition. However, materials do indicate an aspect of being involved in peddling also, apart from consumption. Nevertheless, in the progress of investigation, so length of detention, is directed that the accused person shall be released on bail of rupees 30,000 once of the like the satisfaction of the concern of the
Direct
special judge.
Morigao.
Concern like special judge. And subject to the conditions, number one, it shall cooperate with the remaining investigation. Number two, it shall not hamper or temper activities. Number two, it shall not indulge in any legal activities, including any legal activities of consumption or peddling of narcotics. Violation of the bail conditions, indented cancellation of the return back is that the petition stands not in this post. Appear to receive in the system. Okay. Now,
Have a slide.
Fifteen to view. Three,
My lordship,
the criminal petition.
my lordship, it's a petition for passing of a non-bailable warrant of arrest issued against the petitioner, my lordship. My lordship, what happened was that my lordship initially, my lordship, a petitioner was working on the military services soldier. After his retirement, my lordship, he was working for financial, he was working as Uber driver at that point of time.
Yes.
Uber driver, my lordship, at that point of time. So during that, he has purchased, he has taken on rent one vehicle, and thereafter, because of some discrepancy reasons, an FIR was lost against him, and as such, it was registered under section 420 of IPC, my lordship. And thereafter, my lordship, in the because he was arrested, the bail was granted by the honorable court, my lordship, and thereafter, charge was filed against the petitioner, my lordship. My lordship, during the process, since he was on jail, the owner of the rented premises asked him to leave and vacate the premises on the ground of pretext of increase of rent. He went two violence ahead of that same violence, and he was not at all aware that NBW was issued or someone was issued against him, my lordship. And presently, petitioner was even working, he's working as a trainer for fire services, as a trainer under some police officer and various organizations he used to be called, but he was never informed about the issuance of summons, my lordship. And for that reason, he could not appear in NBW is issued against him. My lordship, petitioner wants to face the trial, my lordship. He has no such past antecedent of this case.
He was indicated as an absconder in the charge.
No, my lordship.
Yeah,
He
yeah.
was arrested,
Oh.
and thereafter he was granted bail, my lordship.
He was granted bail.
My lordship. And my lordship, he was not aware, my lordship. He wants to face the trial, my lordship. Will appear regularly, my lordship, without default.
What do you say? Should I dispose it of? Copies are there, so not certified, copy of certified. Minor certified.
NBW was issued, my lordship, the first was issued on 21/1/2022 and all the subsequent orders. my lordship.
Any submission from?
So the absence since 2019 for the last 5 years.
No, we got delayed, really got delayed.
Because under 5 years, under she approved this board, my lord, and she filed a petition on 26/2025, my lord.
My lordship, I have.
And the NBW, the prayer for NBW, recall of the NBW was rejected.
Let him appear this time.
One opportunity.
Trial will proceed. If he
One
appears.
opportunity may be
Trial, because trial will be, further get delayed. Unless till he is arrested again. On the strength of the NBW. And
Go ahead.
when it comes to issue for the state. You know, filed the instant criminal petition. 528 BNSS. 2020. Seeking a difference with. Only the charge sheet, sorry, only the NBW you want to be interfered with.
My lordship,
Not the-
NBW is
not
issued
the
from,
proceedings.
not the proceedings, my lordship, I will case the trial.
Okay. Taking interference with various orders passed by the learned court below, issuing NBW against the present accused. In PRC case number 1602/2019, pending in the court of learned CJM Amul Pen. The last order is of 23/6/2025.
My lordship, during the pendency of this petition before this honorable court, my lordship, on
Recent
28,
order.
28, 2020,
The last order is stated to be on
28.
20/2025. Learned Council has annexed copies of the relevant documents such as charge sheet and orders passed by the court. We submitted the outset of this case, he had got bail. But subsequently, some difficulties, he could not appear. Whereupon NBWA difficulties could not appear and was also unaware certain circumstances regarding the case. And accordingly, various NBWs came to be issued to. What are the provisions? of this actually? Petitioner is facing prosecution. The aforementioned PRC arising out of Managar PS case number 209/19, in which the charge sheet has been filed under 120B/420 IPC. He submitted that the petitioner wishes to participate in the trial, shall appear regularly. The learned additional submits that the petitioner was absent since 2019. Therefore, learned court below rightly issued the NBWs. The peruse the matter and consider the submissions. I find force in the contention of the prosecution. The continued absence of the petitioner, court below was constrained to issue the constrained to resort to coercive measures like NBW. Nevertheless, considering the contentions and undertaking on behalf of the accused petitioner, and also keeping in mind the interest of taking the proceedings before the proceedings forward. Cash. I deem it fit to allow this petition. Accordingly, the NBW issued wide various orders against the present petitioner. The instant is hereby set aside. Hereby set aside. Subject set aside and quashed, subject to the condition that he shall appear before the. Do you know when is the next?
Yes, my lordship, on 10th of November.
Subject to the condition that shall appear before the learned court below, the next date fixed 10/11/2025. And thereafter appear regularly for the learned trial. Also, not hamper or tamper with the instant criminal petition stands allowed and disposed of.
Of my lordship, thank you.
Number 483 application manner. We are behind the bar for last 37 days. 35 days. Now, my lord, what happened? It is a case of essential commodities act, section 7. The allegation is that in the affair that unauthorized high-speed diesel was found in the possession of the petitioner. And my lord, it was recovered and taken away by the policeman. Now, when they suspect it is stolen, actually, my lord, what happened? We purchase a petrol pump and we sell it in the remote areas where there is no provision for diesel, etc. And only
That is
other
said to
section,
be violative of these provisions.
yes. Other sections are, that is section 7, there is a case matter. Section which is available of it. And other sections that it is a organized gang of robbers, it is not applicable. Not just to detain us, but this section has been applied. Which is section 7 of the essential commodity. Knowing it well, it is a variable, so other section has been added, which are not applicable. 37 days, my lord, everything is recovered. Intervention has been done.
There is
Case I noticeable. Earlier rejection order of case 25.
That I have given you from 4 below, my lord.
Case 30, final facing indicates.
earlier rejection of the by the.
No, I got session 2. Not right.
Session 14.
Page 25 will lock you.
Sorry.
Active, his active involvement, prima facie indicate his active involvement in the organized racket of selling and buying of stolen SSTO being operated from the.
No, there is no allegation of a stealing of any.
Get the case there, yeah.
Yes,
Better.
95 days already behind the punishment. Only essential commodities the act will be applied.
Immediately after reopening, yes, it's first day. Case diary is properly is not yet received. So, learn it to counsel and see this also.
So the law will not consider the essential commodities act.
It's out that petitioner is in detention for petitioners are in detention since 5 days. Prosecution draws attention to the order dated 9/9/25 passed by the court below in the bail petition. Nevertheless, issue press reminder for the case diary released on 13/10. Yes.
21 scan copy of TCR was called for not being received.
He was not called for, only charge sheet and the deposition of the, with the victim lordship. But that is, I have annexed along with my petition lordship. In this case, lordship was order on last.
Order has been impleted.
Impleted lordship and other engage the council lordship, he is appeared. So my lord, here is the affidavit lordship, he has stated that the member already fixed the matters between the petitioner and the victim guardians. That is mentioned in the page number 29, para number 5.
In custody since
He is in custody since lordship
April.
38/4/2025. 38 of April lordship. 149 days lordship already.
Pregnancy.
Lordship, pendency before the Foxos Judge Lordship, Kanro Metro, Special Judge Lordship.
This case, petitioner is in custody 66 days, my lord. Kindly see the ground of arrest, my lord. Page 50.
Allegations.
Page 15, allegation is 310, my lord. There are two parts, my lord. One part is 301 is 60 days and 302, 10-2. There is
Decoity.
decorative.
That's.
My lord, kindly see the ground of arrest. Page 15. All the accused has been arrested, my lord. Ground number 1, my lord.
Recover the stolen property.
Yes, and I am the Tuton Das. From not, I am Tuton Das, not from my possession it has been recovered. It has been recovered from Saurabh Palmer.
Is he named?
Yes. Sir. In the affair, there is
Decoity. Any, is there a call for is not a fee? Issue press reclamation. List on 14. 14.
yes, my lord, can it be, my lord?
Earlier.
Interim,
No,
because 66
in my opinion, decoity is a very serious, very serious.
in the ground of
Alex.
arrest, my lord, is
Alex,
specifically
public safety. You have to be safe at night when you sleep.
Your lordship, can you make kind fast for time?
Second bill application. He was
Okay.
25 days. Account to the 54 days. Statutory period will be over on 2nd October.
That kind of the second bill.
Second bill. Earlier, bill application is 26. Earlier also he was arrested in another case on 2025. Thereafter, we filed a bail application before the last file for.
There is it.
So if you say serious offense, my lord,
Yeah, yeah.
right? You have to be rejected.
The eligibility.
Will not be varying the length of the
Completed
period.
is 10 plus 2.
I understand. No, by you wrongly remove one. You remove wrong. Temporary lady.
In that case, no, sir, we granted bail by the landed court below. Where placed up.
Rejected only on 16 months.
16 night.
60 days offense. Up to 7 years.
Complete.
You have to edit section is also there.
Added section of
Yes. Written,
homicide.
yes.
Up to 110.
Yeah, I mean, if you say homicide can come.
Up to
No,
7.
it can come.
Up to 7 years.
You cannot. Calculate homicide.
No, sir, up to 7 years. 60 days.
First name is 90 days. Second name is culpable homicide, not amounting to murder. Which section they are, which limb they are invoked. Anyway,
And only on length of the case.
16 days actually. Investigation is the most investigation. I would show you. This subsequent jail application filed after rejection of the earlier one on 16/9/2020. The refusal of fishing. Here is the annexed order. Is there any scope for the been received?
Is also the organized.
Organized crime here. This one is organized. How can it? New definition of organized crime is there now. You have to see the interpretation. Peruse the relevant parts, especially the recent endorsements in the case there. In my opinion, it would be prudent to allow the investigation to be complete. Therefore, the subsequent petition stands rejected at this case. Turn back the case there. Then you take, contents, it's not complete, take statutory bit. You want me to make an observation? Not necessary. Not necessary. That's automatic. Statutory bit is not related to any rejection by her. I agree with that.
Yes. 60 days of his lordship and the petition was is in custody for last 24, 35 days. And your lordship period page 21.
On 15/9, my lord.
The case there is come.
Yes.
Lordship period service is 21. Finally, this custody was sent for thorough interrogation. And may I take your lordship to page 21?
Page 21.
Yes, lordship.
Was
What?
custodial examined for 5 days.
Yes, please demand for the thorough
But this,
investigation.
this what
of the-
5 days, but I don't know. how many-
Yes, and thereafter, lordship, since the day of his judicial custody, not a single day has been visited. Why is lordship? In fact, your lordship, yes, already been questioned what was the required statement, signature, his bank, details, everything has been seized, lordship. The last opinion, lordship, by calling for the up-to-date status has been called for. Whether they have been received. Whether the specific question, whether his further detention.
Serious offense, cyber offense. They were earlier rejected only on 15/9. How these persons will develop, say the organized cyber offense, how this person will affect my lord. In the name of the present, it is 8 persons, there are 5 bank accounts. They can please they have no procedure.
Lordship has already,
I've seen this.
lordship has already perused the diary and thereafter considering certain material, lordship has rejected. And thereafter, lordship, if your lordship remember that, whether specific question, whether he's
What is the
further
name-
detention.
Name of this person, Sergeant.
Sergeant.
He is the main accused.
No, he's not the main accused, lordship. The main accused, the one Chan, Prabhu Chan has been released on bail, lordship. That the other accused has already.
Other accused also, sorry, other cases stated with any, yes. So, similar type.
Lordship, whether that question, that query has come before your lordship, that whether they want further, if not, then lordship may,
There should be some basis. Otherwise, if you determine, penalize someone for antecedents, there should be some materials.
no antecedent, lordship, never he was, involved in any such activity, only thing, lordship, his bank account has been, used, lordship, that is the
Yes,
allegation.
5 different accounts.
May I pray, lordship? May I pray this, is to post on the.
And then it has to be sent back. That constitution.
No, lordship, whether that report regarding that, if not, it has not come, then yes, absolutely.
Rejected on, you know, the case.
Up to date part is not come, then lordship may fix it for updation, fixing the.
The case diary has been received, short filling. Part 2, absolutely. Case diary has been received and is reiterated by the prosecution that the offences are of a serious nature and present accused has been significantly implicated by the investigation. At this stage, learned counsel but on the perusing, I find that the last endorsement is of 11th September. 2020. The CD will be sent back, yes, and returned again with the latest investigation, up to date or latest investigation. The bill petitions have remained pending list. Petition which was has been like take it on 22.
Lordship 1310, let it be on 1310.
There's been not much of
Let us take a chance. Lordship.
On 17.
Let it be.
17.
Yesterday, my lord, matter was taken up. My lordship was pleased to direct them to obtain medical report, your lordship. FIR, my lord, will find a case 10.
Just
55 is probably taken up of
some time to the
complete some.
okay.
FIR, my lord, 10, page 2. Love affair, my lord.
You want after some time?
Yes.
Quickly, your lordship, 483 application lordship. There was arrested on 7/10/2023. Today is about 1 year, 11 months, 17 days lordship. In this case, we have taken the plea for non-compliance of the notice under section 50 and 50A lordship. Lordship, I have annexed that page number 27 lordship. Check without the grounds notice under 50 has served and lordship, there is no notice under section 50A lordship. It is in the record also, I have gone through the record also, there was no notice, we have found lordship.
P6, scale.
Receipt.
Scan copy is received.
Receipt.
You just check them on that aspect because otherwise we'll have to go into 37, which is not her contention now.
Lordship, only
She
number.
has only updated about land council about this non-compliance. So this probably is not, there's no complaints with this. 50 is clear.
50
50A also
50 lordship without ground lordship and 50A is not there.
not there.
50 is lordship without
There,
ground,
but no ground.
no ground,
50A is not there.
not there.
That's a fact. We just have to find out whether it's there.
Then I will go through the rating.
I have gone through, I have not found lordship.
Team confirmed. Short.
Wait, please. Instead of
57.
Kidnapping of a girl who has already been recovered yesterday, lordship. One. As on today, 40 days, your lordship, there is 60 days period is there. Girl, even before filing of the FIR recovered, immediately she was in minus.
one small issue is involved here. So lordship may kindly examine.
He's the driver of the truck.
Yes, madam. So, my lord, here beef, 28 kg of beef was found from his possession. And this way, as per the FIR, my lord, if I may read the first paragraph. With reference to the subject cited above, I have the honor to report that on so and so date, reliable source information received that a person was carrying suspected beef in a motorcycle bearing registration number so and so, coming from Khamarpara, West Bengal area to Assam, via Grahampur. Accordingly, the content of the information was affirmed. So, allegation is that I was bringing beef from West Bengal. Now, under the scheme of the Assam Cattle Preservation Act, the offences are committed when cattle is illegally slaughtered
there's a prohibition on the slaughter of the cattle. So my lord, if there is a
Without license.
without license in terms of section 5. Section 4 carries the general prohibition on slaughter of cattle. Then there is my lord prohibition on the transport of cattle in terms of section 7. And section 8 prohibits the sale of beef, my lord. Now under the
Again,
scheme,
without license.
my lord, sale of beef, there's a certain conditions like it cannot be within the 5-kilometer area where temples are built. No, my lord,
Slaughter is prohibited without license.
transport of cattle is prohibited.
Completely.
Oh, no, my lord, regulated from if there are some certain conditions, then my lord, sale of beef again subject to conditions is prohibited. But there is no prohibition on transport of beef, my lord, under the act. If your lordship will kindly have the act,
Cattle
cattle is prohibited.
Cattle versus meat.
And here, my lord, this beef, as per the prosecution's case, is procured from West Bengal. This act does not extend to West Bengal. So even if the cattle was slaughtered in West Bengal, by whosoever, my lord, it was slaughtered in West Bengal where there is no prohibition. And if I am only procuring or transporting beef from West Bengal to Assam, so I am not covered by the provisions of the Assam Cattle Preservation Act, in my respect.
You have received the case there or to be discussed.
So you have received
Case like that. So 13 kg, 15 kg to that's 28 kg takes for recover from the.
This is an interesting point, but
Yes. Yes, that's why it's that
because the criminal law has to be interpreted strictly. Animal does not mean, cannot mean animal meat.
Yes, very
One piece of, say, chicken, it is not equivalent to a hen. Kind of this.
As far as his statement was, yes, collected the beef from Hamarpura, West Bengal area, was proceeding plus Rahampur side. The beef was intended to sell for Rahampur area, Rahampur, Hakurpur and Morna.
Slaughter section.
Minus section 4 and 5.
Transport 5.
No, 4 and 5. 4 is the general prohibition. 5 is the regarding the
Transport is 5.
transport is 7 man.
7.
Sale is 8 man. So that issue and the other issues in the case diary, those parts are not disputed.
Yes, I am trying and selling beef without very license.
Considering the length of detention and this aspect,
It's now. Detention since 5/9/25. This invoke section 483 BNSS, seeking regular bail in connection with the Saigon case number 132. Section. The learned. Contents that are of the allegation in the FIR dated 5/9/2006. In a nutshell, that this person was allegedly illegally carrying suspected meat in the nature of beef in his vehicle coming from West Bengal. In some extent, the sections 4/5 of the Assam Cattle Preservation Act 2021 prohibits slaughter of cattle without valid
without certificate from the competent
without proper certificate. Section 7 prohibits transport without proper documentation and permission. And section 8 prohibits transport of cattle.
No, section 7 prohibits transport, section 8 prohibits sale.
Oh, sale of meat. Sorry, sale of cattle.
Sale of beef and beef products.
Sale of beef and beef products without proper permission. and subject to regulations. The case diary as follows has been received. The prosecution submit that suspected need in the nature of the quantity.
Approximately 28 is included 15 and 14 please, which
Were on with the resolution. And that we have also admitted that of transshipping the same from West Bengal in its lake. Can I have a look at that? Diary has been placed before me. Relevant questions page. Seeing the progress of investigation. Come back with it. Well, there may be a deficiency in the drafting of the law, but it says sale of milk.
some
You cannot sell, but for sale, somebody has to bring palm on Western. Or maybe sometimes not, but usually. Investigation is not yet completed. Not the, that is important. Absolutely. What we see actually. Meat, suspected meat, has been sent to FSA. In the circumstances and upon perusing the details, I'm of the considered view that while the investigation should be allowed to be completed, the use should be granted bail at instance. It's not beyond the matter. Used is not allowed to go bail without on surety of the life, the satisfaction of the concerned learned group.
SDGM M Gosaigaon.
Subject to the condition that is a cooperate with remaining investigation, number do not hamper or tamper with the evidence. Number two, not not misuse his liberty to commit any illegal activities, including any activities prohibited under some capital preservation. 2020. Okay, fine.
I'm deeply observing.
Assisted by. Send back the case to choose person. Okay.
Yeah, please, your option.
Production. Sorry.
May I please, your option. Item 59, my lord, is a regular bail application. This my lord petitioner, he was arrested on my lord 37/25 my lord. He has completed my lord 59 days custody as on today my lord. But case is my lord 103 murder. So lordship will kindly come to the my lord FIR at page my lord 14 my lord.
Yeah, yes, I'm on 14.
May I, may I read it, my lord? With due respect, this is to state that on 23/7/25, date of occurrence 23/7/25. At about 7 in the evening, my father Sibu Kharia, while returning home from Mohabanda daily market, Muhammad Mainul Islam, son of unknown, he is the father of the present petitioner, my lord. His son Ronit Islam, he is a my lord juvenile, he was arrested and my lord given in custody of their parents.
Rohan Islam.
And Rohan is the petitioner before your treatment. Our village, without any reason, gathered my father in front of their house, and in order to kill, their blows kicked and slapped, causing grievous injuries. But it is a matter of regret that as our financial condition is very poor, we could not give medical treatment, and they had cheated us by not giving treatment to our father, though they assured.
Yes.
The connection with Grappa case is number 26 of 25. 20B, other section 23. 20B slash 23B small of the NDPS. The delegation is about recovery of an intermediate quantity within bracket 10.13 kg suspected cannabis guns up from the accused person. Case diary has been received.
It seems to be in very peddling.
Peddling also.
Yes. Because otherwise, the post and the quantity of the
Quantity, yes. Then you got consumption. Investigation is the progress of investigation, NDPS cases, there's not much to be done.
only when a people official report notice is
Yes.
cigar witnesses from
Yes,
their statement is there in their presence.
sampling also done. Sampling has been,
Yes.
sampling.
Yes, sir.
The learned additional PP on the basis of the case diary
Sampling.
submits that the investigation has progressed and is pending for receipt for FSL. FSL report. However, it has revealed implicating records against the present accused, also indicating his involvement in peddling. The witnesses have been examined first and sampling also done.
Yes.
Considering the progress, despite adverse materials, considering progress of investigation and the length of detention, the accused Swenso is hereby allowed to go on bail of rupees 50,000 with one surety of the liability, the satisfaction of the concerned learned court.
Special class Nalbari madam.
Session judge Nalbari. It may not be session judge also. It may be concerned. Session judge.
Special class.
Special. Nalbari. Whoever the special judge is. And subject to the conditions that he shall not abscond and he shall not hamper or activities. He shall not indulge in any illegal activities, including any activities prohibited by the NDPS Act. Return that is that the petition stands allowed and discretion.
But
Okay.
56 minute I have said from the TCR minute that
Not that. Assisted by good news.
Thanks, madam.
The petitioner Pramod Kumar Mathur seeking regular bail in the 483 BNSS in connection with NDPS case number 65 of 24 arising out of GRPS 194/23 number 20B2C. He was arrested on 7/10/23. Oh, long detention. No, commercial.
7/10/20.
Very lucky to get on this ground. Otherwise, 37 is a very tough.
Yes,
Not easy, not easy.
but he has not approached.
It is even tougher than UAP. Because there it is prima facie true. Here it is not guilty. Very difficult to say not guilty until once some new materials are found.
Only on this ground, many of the NDPS cases, only because of non-participant.
Very interesting. Learned counsel. Nargis has raised a preliminary contention that notice under 47 BNSS is inadequate and notice under 48 BNS was not given. peruse the annex copy. Oh, 50, no, not the annex.
50 and 58.
Sorry,
50 and 58.
50 CRPC. Or something, what is it, 50 CRPC, 50A CRPC. Peruse the copy annexed to the bail petition. The learned, on a query by the court, the learned additional PPS fairly submit the perusing the records that this notice is there. 48 is not there.
15 notice is there.
This is the
Same notice.
same notice that that notice under 50 CRPC is the same one as that annexed, and notice under 50A is not available. The case of Ihan Kumar. In the aforesaid situation, the accused has to be granted bail. Accordingly, it's allowed to go on bail of 50,000. One surety of the life and the satisfaction of the concerned learned court, subject to the condition that the government shall not indulge in. Bail petition stands allowed and dispensed.
Pending for special risk amendment.
Concerned learned court. That is absolutely safe, but within, if you are sure, then we can write it within brackets.
Sessions as
Special-
metro.
Special. It may not be session judge, it may be additional session judge.
No, sessions as
No. But we also take, I think,
That's
everywhere they can take. It's go a little fast.
May I please, the Lordship, this is regular bail application, FIR is page number 12. My lord, the petitioner is behind for 36 days. Offense under section 420 and 406 IPC.
Show the animation.
Last occasion CD was called for.
That is specific. Some financial fraudulent loans.
Yes, some they have collected from Aadhaar card, PAN card from the various persons of chip and taking loan in the name of them. But after when they were, the victims were applied for a loan, they found that their equal payment was there.
Where
civil
loans were actually taken in India.
Yes, again. Several witnesses were examined, they have included, yes, they can, yes, they has taken the Aadhaar card and PAN card from ourselves, and they can loan there. After default payment, default was done, the day after they have, that's why the delay of filing FIR.
My lord, small amount, 4,000 and it's 4,000 and total amount is 2,50,000.
4,000 from various people. So haram money of the poor people.
36 days, my lord.
Restitution with the
I think this is, how many persons here seated? That is, yet,
My lord, he is the bread owner, my lord, just feel, and he maintain his family somehow, he's on it. Kindly allow me.
so hard to some. The allegation pertains to fraudulently taking loans in the name of the villagers, and that the FIR was filed. The victims came to know about the same. Regarding default of such supposed loans in their name. At least, Learned Council submit that the accused is a sole breadwinner and that he is in custody since 21/8. The learned prosecution on the basis of the case diary submits that all the alleged victims have implicated and their investigation has lent support to the allegations and that the victims came to know about the incident only when they got notices from the bank for defaulting in loans which were fraudulently taken in their names. Investigation is in progress. At this stage, the bail stands rejected. Return back the question. Obliged. But in matter, petitioner number one, he was arrested on 31/7/25. And petitioner number two was arrested on 22/7/25. Till they be 57 days and 66 days in custody respectively. But you will find the FIR is at page 15. 11. There is come. Yes. Page 24 is the FIR. Death of the woman. Death of the woman. Now here in this petition, the petitioner number one is the brother-in-law of the victim, and petitioner number two is the husband. Now, although initially case was registered under section 109, but after the investigation, because section was added 108 because it is a pure case of suicidal abatement of so, page 27 is the forwarding of the application of the IO. That section was added. The facts disclosed, my lord, will find at page 27. FIR is that? FIR is at page 24. This has been lodged by the mother of the victim. All the family members' names are given, except the petitioner number two. In the FIR, this has been lost by the mother of the victim. No, I remember this, and it was lodged. Absolutely no ingredients of section 108, but only two things, what it appears, so far as petitioner number two is concerned, is that on the video calling, there's some demand of money, all these things are there. The homicide aspect should also be there now for the crime. That was already there. They've added. Added, rather from this application, it would appear 109 would not remain, except 108. Those can also done. No. Then the FIR is not anyway. Let's come to this. So first, petitioner number one is concerned. His against him allegation is that there's a family, there's a dispute with regard to the land, and frequent quarreling is to be taken place. On the date of incident or at the time of incident, in fact, the victim was having an Instagram video calling with the petitioner number two. And thereafter, she committed the suicide. So therefore, the direct connection or the direct instigation as such is should be absent.
So, PMP is pending, lots of openings pending. What make a statement from you that what's what I meant is your statement.
It is revealed against this person.
Yes.
Harassment.
Complex.
Quarrel, not quarrel is quarrel necessarily is harassment, but
Harassment was there.
directed harassment
Yes.
also that is different. Quarrels would take place unfortunately. In family members.
Used to threaten her, even assaulted her also. It's complained to police several. He gave complaint to police several times, and every time police sent the matter to court stating as domestic violence. And Dixon promised to not to repeat again. So her husband brought his such
the person that he lost all his business and he did not support her when she lived. It was shooting and assault purpose there, as far as statement of the witness about checking and
To clear, time constraint. Go first.
that's why the probably later part that section is added.
Yes, sir. So, and what I will an additional. First is seeking regular bail in connection with Warrant case number 76 of 24. So the section change as well. He was arrested on 22/7/2024. The petitioner number 1 and 2 are stated to be the brother-in-law and son, husband of the deceased. The allegation in the fire that the named FIN persons, including the present accused, conspired and attempted to kill the informant's daughter. Its name is not there in the FIR, so it's not there. Including petitioner number 1. Past act, perhaps one of my submission cannot be considered as an ingredient or an act of direct instigation. The recent decision also will rely on the earlier decision of 2017. This was clear by the suppress the act. Section number 1. So, that attempted to kill her daughter, and that her condition was serious, and she is under treatment at UNCL. The case diary as called for has been received. We submitted by the learned additional that there are materials revealed by the investigation which lend support to the allegations in the affair. We also submitted that there are materials have been collected by the investigation that both the present petitioners were involved in inflicting all sorts of torture upon the deceased. Stop. the statements of some of the relevant witnesses have been placed before the court by way of the CD test that gone through those statements and find force in the contention of the prosecution. Considering the nature of the case, the bail petition stands rejected at this stage. Return back the claim. Stands disposed of. 60 was connected with this CD. 60. 68. Even anticipatory bail method by the father-in-law and the mother-in-law, and one of them brother-in-law. Have you seen with regard to
Allow me to say that the time was rather than the one. So whereas the just statement of the impact is there.
that you check, take it up after selection.
It is 64 minute, is there a receipt minutes? Along with the legible copy of the 164 statement.
Legible 164 state.
164. Day before yesterday. With the legible copy of 164 statement.
So the 30 count is.
Yes.
See the, there are these persons.
Sixty-four statement, one, 4 pages. So she implicated and regarding,
Who are the present petitions?
second petitioner, Azimuddin, one Sohidul Islam.
No?
One Sohidul Islam.
Or the other one, other petition.
Regarding,
They are the two persons who were stated to be in the car.
yes, yes. Yes. So after allegation is that, she was a cleaning worker, for the purpose of some cleaning work, they
Yes, sir.
thereafter.
We have seen that statement. You see the legible. Oh, yes.
Regarding transfer of an amount of rupees 20,000 to Sohidul. That also, the incident occurred here on 3/6/24. And that the amount of 20,000 was been transferred to Sohidul's account. For the cleaning worker, why they demanded an amount of rupees 1 lakh and thereafter.
Yes.
And thereafter also look at those ornaments for the people, some of the.
Yeah. There will be more to it.
Yes.
And mixed type, but on
There
the,
are some
but this is a magistrate statement.
Yes, yes.
People start lying for more, then you can no longer find the truth.
Yes, yes.
You have to fail.
And regarding allegation of that is there.
That is there. Well, the allegation is very serious, right? Since 97. Investigation. Serious. His diary has been received.
Yes.
Lordship,
You make your submissions.
may I please, your Lordship.
What is the other? Give me the other one.
Lord-
That is a B or AB? Both are
Yeah,
B.
both are BA Lordship. Today is 80 days Lordship. Considering the length of detention Lordship, statutory period will be over on 6th of October Lordship. So my humble submission before your Lordship, considering the length of detention, your Lordship may consider both the bill, my bill petition Lordship.
You also submit that. So we do this.
Yes. In fact, my lord, His FIR has been lost, my lord, after about 15 days of the alleged.
Please be short.
Yes.
Time constraint.
Yes, yes. So, my lord, your lordship will kindly have a look, my lord, page 24 is the FIR, page 40. Yes,
I will not see that.
yes, my lord. But your lordship will
Your
see,
just a contention.
yes, yes, your lordship will see that she following a phone call, which is from one unknown person, my lord. And she came voluntarily, my lord, and then, my lord, got into the vehicle. And since, my lord, 5 o'clock to 11 o'clock, my lord, till night, my lord, she was traveling, my lord. And, my lord, she never raised any, my lord, noise that, my lord, she was having some, any problem, my lord, there. And
Yes, the execution of one or
Is there is not received issue reminder. 1410.
1410 your lordship, but then 48 days. Will be
48 days.
more than 60 days.
More than 6.
Maybe in the vacation code if your lordship may kindly tell.
9, 9, 10. You know what's happening now? Therefore, the law actually wants to rehabilitate the
Yes.
consumers and punish the sellers. But, most of the small time consumers, yes, this case cannot reach us. Generally, they are also small time consumers, also small time payers.
Yeah, exactly.
They finance their consumption. By
Yes, sir.
that is the thing. They have to be rehabilitated, so wind away from there. At the same time, the peddling is also the. This is the difficulty.
And there was a made your lordship, but.
Police
people
gets
were-
very angry, believe me.
Mm.
I've seen on the ground that, NDPS cases, they said that lot of difficulty, but anyway, we have to court functions independently. We take our own view. So, I have a point also.
I'm very grateful.
No. problem. So maybe after some time.
68.
Interim.
Interim, they have statement is after getting intent of product statement. Okay,
Okay.
number 3. I gone to the case study. So specific against the family members, these allegations are there. But I have not found any specific allegation against him. Other two brothers have allegations against them, but they have gone to the case study as well.
Other two, this,
This
Kunjalal.
they have no intent. You are intent.
Petition number 1 and 2 are interim. Petition number-
He is not in intent, but I have not specific allegation against Dilip Aghari.
You should, then you want her, their statements.
Yes.
So, we extend her their interim, grant you interim,
Okay.
and fix it up. The petitioner number. Yeah. Petitioner number 1 and 2 were granted interim date on 15/9/25. Yes, that is received to you. And learned additional people, submit that the statements of the petitioner number 1 and 2 are not yet available in the case diary. Order submits that on perusing the CD, you do not find specific materials against petitioner number 3. In the circumstances, the case diary may be sent back and procured again with the updated investigation, including statements. The interim granted to 1 and 2 stand extended to the next date of listing. Further, it is directed such identical order that in the interim, petition number 3, namely, Dilip Aghari is allowed to go on end of 25 in the event of its acts. Subject to the satisfaction varies in same condition. List after the petition, yeah, have it a little late.
22
Little later.
Yes, for 28.
I am on interim lordship. Case diary.
26, diary not received. Not. Wait, 26. Case diary is not yet received. Issue fresh reminder, interim bail granted by order dated so and so. Time. 10/2/2025. So it's still extended to the next date of this team. East on 27/10.
27 also in this case, up to the city was called for. So the city was not up to date, also the city was not taken by the statement of the interim was done earlier also, the statement is not taken by.
No problem. Let's get the updated case diary. The updated case diary is not available as the CD was not taken back. The same shall be sent back and returned with the updated investigation. The interim bill granted by the order dated
28/4/2025.
20,
28/4/2025.
28/4/2025. Stands extended to the next date of this.
27.
27/10. Okay.
Deeply on.
May 27/10. Item number. What is it? What is it?
27. Yes, 27, I think. Aliwa.
May I please your worship? Worship Angus counsel is out of station. Perhaps CD is not there.
But in this case, search sheet certificate.
Golden boat. Thirty-one seven plus one. 21 second. Second. 21 seven. The accused, the petitioner was granted interim clearance bail on 31/7/2025. The current prosecution submits that charge sheet has been submitted in that. In view of the same, the interim bail granted by the order is ever made absolute, subject to the condition that this shall be available for the trial. He shall be available for the trial and shall not hamper or temper. It's supposed to allowed and disposed, right?
Article also update city was called for getting intent statement of for in the case diary. So update city will call to us.
Up to date case diary is not, it's CD is here.
City is here, but not update. Not taken back.
It is submitted by prosecution that up to date case diary is necessary. Accordingly, the case diary is sent back, may be sent back and returned back with updated investigation. Interim bail granted by 13/8/25 and continue to next date of this. It's also let it be on
28/10.
28/10.
Case diary.
Lordship,
Is there-
petitioner number 5 to 10 are on interim lordship.
5 to 10.
That's
Case diary is stated to be not received. Issue fresh requisition. Interim, last time, for the interim or past 25 cents in respect of petitioner number 5 to 10. Will continue in the next date of this. This one, 28/10, not 28.
live.
This is search sheet subject.
My lord, I was earlier in the.
Yes. Panel 1, 2, 3. 3 set. The petitioner was granted interim clearance bid on 4/8/25 for the reasons stated therein. Prosecution submits today that charge sheet has been submitted. Accordingly, the interim bail is hereby made absolute, subject to the conditions that shall be available for trial and subject to condition, will not hamper or temporary. Allowed and disposed.
Must.
Everything we have received the information that first six submitted.
Yeah, true. Not interim, no interim.
What did you?
No interim. Or is it joinal abedin? Yes, joinal. Bosaigao PS case number 45 of 25, registered under so and so. The prosecution submits that in the meantime, charge sheet has been submitted. In view of the said development, it is directed that in the event of arrest of the petitioner in connection with this case, shall be allowed to go on bail of 25 on severity. That's the issue, arresting and available for that. This was.
35 is a regular bill. Your lordship, the petitioner is the father-in-law of this lordship. This is deceased lordship.
Yeah, diary is received.
We have received the diary, but opinion regarding postmortem exactly is kept pending in the report. It's a right point. And then in injury photos, there are multiple bluish colored blues of varying size ranging 0.5 cm to 0.5 cm. 1.5 cm to 1.5 cm on both lower limb below the knee. And now this is concerned, they are implicating the family members and along with the issue, husband.
No, husband is still absconding. Husband is absconding lordship. This is the father-in-law lordship, arrest bill.
Yes, would be.
Yes, and 54 days. And the while passing interim in out of 2% were granted interim lordship. While granting interim lordship have directed to obtain the note of the regarding the cause of death lordship that in postmortem report. So may I pray that may be kept pending after vacation lordship, and regarding this regular bill lordship may pass an order. Interim duta kiya hai usko.
As you wish. Petitioner number 2 and 3 herein. Maybe 2003. Petitioner number 2 and 3 herein were granted interim bail on 15/9/2015.
Their statement not like a there.
Not in a different. Yes, there is receipt, but their statements are not available. Moreover, the opinion regarding debt is also awaited. Therefore, the case diary may be sent back and updated diary may be sent along with statements and debt opinion if any. The interim debt granted to petitioner number 2 and 3, shall stand extended to the next date of listing. He is old person slightly, but their materials against him father-in-law.
They have taken the family members, according to husband and all the family members of also have. Because of that, we also lost her child in the
The present accused, Yasuddin, stated to be the father-in-law of the deceased, who was arrested on 3/8/2010, stated to be aged for 65 years. Is submitted by the prosecution on the basis of the case there, that there are implications against the family members, specifically against him.
Not specifically, Lord Sabha. And the husband along with the family members.
That the allegations against the husband along with other family members, rather than any pointed allegation against the present, against the father-in-law. Considering that aspect of the matter, of the length of detention, and also his age, dash, accused here, is hereby allowed to go on bail of 25,000 once a satisfaction of the concerned government. Shall not empower or tamper with this. Cooperate with remaining investigation, not tamper or tamper with this. Allow them disposed.
Much obliged, Your Honor. Much obliged.
All were granted interim bail. 26. Also, 3 paragraphs. The prosecution, learned prosecution submits to them that in the meantime, this has been charged sheet. In view of the completion of in view of the completion of investigation, the interim bail granted to the one petitioner, the petitioner, by order dated 26/8/25, is hereby made absolute, subject to the conditions that are available for trial and would temper or tamper with it. Allowed and disposed.
And the applicant is the law manager, in the PSU bank. And the complainant was one of the director of the brewer company, madam. And he filed FIR in 2019, madam. In 2019, he filed this FIR. After 6 years, they issue section 41 notice to me regarding the forced signature of the accused person. The persons against whom we have filed the debt recovery proceedings for the recovery of the public money.
Oh, I see. Now I remember.
Yes, ma'am.
In the DRT proceedings,
Yes, right.
source documents.
Yes, ma'am.
Were supposed to be some.
It was listed there before.
Lord, my lord, this FIR was in 2019, madam.
That means,
After 6 years,
they connived with those firms.
Yes.
In submitting force documents.
Yes.
It's a complex case.
Could
you go through-
I have gone through the case.
You gone through?
Here initially the present application, present FIR is filed against the present petitioner along with some of the officials of the HUDCO. Allegation is that one original application is pending before DRT. And in that DRT, one additional affidavit is filed by the accused person. In that additional affidavit, some of the, my lord, agreement and document, this was earlier, my lord, executed between the, my lord, between the one
Business firm.
HUDCO and one McNass, one construction company. And that loan agreement, some signatures were closed. That is the allegations, my lord. And on the basis of that,
Affidavit was filed by.
additional filed by the.
not by me, my lord, the another officer. Another officer. I'm the law officer.
While going through the city, I have initially one of the present complainant when his wife was the earlier director of that construction company. In the year 2006, he joined after obtaining Assam Police Service. He, my lord, thereafter left that directorship of that company as per his from the contents of the affair. Thereafter, my lord, he also, my lord, he submitted his resignation before the, my lord, office of the, my lord, company, my lord, thereafter, in the year, that is, in the year 2006, 2004, man, in the year 2004, he resigned from the directorship of the construction company. And now his allegation that this agreement is made in the year 2006 between the construction company and HUDCO. And on the basis of that, my lord, agreements, some loan were provided to the construction company. And now, my lord, that financial, my lord, bank has received notice to the present, my lord, complainant that you are liable for that loan amount. Thereafter, entire dispute arises because as per his statement, he has already left the company in the year 2004. This agreement with the bank is in the year,
Sangeeta Das,
yes.
Sangeeta Das.
No, ma'am, not Sangeeta. The complainant.
Complainant.
Complainant. Sangeeta Das is a law
There are
manager. Law officer. He's part.
Thereafter, old file in the year 2010 before that.
Can we think of one option that investigation is going? Because I understood that, but not fully understood. Yes, it's complex. So, can we ask her to record her statement? And then the diary will gone back and then investigation progresses then. Yes, because I cannot reserve also 2 times.
Yes, sir.
Holidays
I
are
have
over.
also checked the earlier one of PSK CD, FIR and the earlier CID FIR also there. Almost same set of allegations regarding one of forging his signature. And in those cases, one of search sheet submitted. And the official report also received that his signature was forged. Regarding that report is also there. It is also in fact mentioned in the FIR itself. Yes, yes, okay. Let him record his.
Because this case, I think we'll have to reserve. I can study it properly.
Against one loan, same set of accused persons, 3 FIRs lodged. And out of 3, 2 are already investigated.
The present petitioner, Sangeeta Das, stated to be a legal officer in the Housing and Development Corporation. He's seeking anticipatory bail in the 482 BNSS in connection with CID case number CID case number 28 of 2019.
Yes, CID.
The 120 to 460, the case is
No,
also very old.
63/2000.
Huh?
CID PS case, present case is 20.
Present case is 28 of
28.
2000.
I'm going by there. Sometimes we should cross check also. You can also make a mistake. Because these things, if there is any mistake, the bail order, you will not be able to get the benefit of the make a mistake in the PS case. The gist of the allegations is that some officials of the corporation and that some in an original application before a DRT, some forged documents are submitted by certain business consultants
Law officer, no, my lord, from the HUDCO.
from the HUDCO, and that the present petitioner along with other officials were also responsible for this. It is alleged that other cases, particulars of which have been mentioned, were also registered and 2 of them charge sheeted. The case diary is received despite the fire being of the year 2019, investigation is not yet completed. The learned additional PK submits that the allegations in the other cases are also on similar lines. Nevertheless, it appears that the factual metrics and the immersed materials in the investigation will require more careful analysis. At this stage, I deem it proper to direct the petitioner to record a statement before I with interim protection. The case diary may be sent back and returned back with updated investigation, including the petitioner's statement. In the interim, in the event of arrest, 25,000 concealed. Cooperative investigation. Appear before the examination, not hamper or temporary. Give them some time, 29. Develop. Then we'll get a more complete picture. Not yeah. Long time.
May please the lordship. Pre-hearing bail application matter, petitioner, two petitioners matter, the appeared matter, the statement has been recorded matter. There are actually, well, there are cases and counter cases against both the parties, the lordship.
Diary is received.
Yes, diary is received. But if you. Interim lordship.
Yes.
Bail order is here, lordship, in the case diary. The statement I have not found.
Actually, there is a long history of cases against the parties, madam. The accused persons are the informant's husband's brother and uncle.
Rape allegation.
Yes,
Rape allegation, but my lord, there is.
Petitioner is in interim. We have not received the case diary.
Did it come after vacation?
My lord.
Extension of
My lord.
11:9. The case diary is stated to is not received. Issue fresh requisition. Interim bail granted to the petition, right order dated 11:9. Stands extended till the next date of list.
Oblate.
List we can say, give a long date.
29.
List on 2019.
Time being.
Sorry, my lord, I was not there, my lord, when it was called.
No,
The second application, my lord,
yeah, no,
that, what should be that earlier order, my lord, starts from page 79, my lord. And relevant, it was 80 and 81, my lord.
Huh?
Relevant, my lord, lordship observation, page 80 and 81, lordship, thank you. It was rejected at that stage by. No, lordship, only the length of detention, my lord, on Navik, my lord, I mean,
59. 10 days.
father is sick, my lord, neurological disorder, my lord, that we have annexed, my lord, some documents, my lord. He has learned a lesson, my lord, strictest of condition, my lord.
Expert talking about it. 70 days. 2, 4. That's fairly submitted that this is a subsequent bail petition. The earlier petition was rejected by this court on 15/9. The perusal of case diary. Updated case diary is just recent again.
Yes, same as possible.
Same. The investigation has stated to have not progressed the last 10 days. So the objective situation remains the same, except the additional 10 days of the detention. I have found, perused the grounds of rejection in the earlier order. The investigation is still in progress. I do not find sufficient new grounds in the subsequent petition. This accordingly also stands rejected at this stage. return back the case study. They are in custody since.
It will be around a month, my lord, and can it come up then in the after vacation, if your lordship, kindly?
File a fresh one. In the meantime, I think it is approaching charge sheet, maybe. No, no, there is progress.
There is progress up to 10-9.
10-9 is earlier, possibly, my lord.
Threat of viraling photographs and all that.
But 10-9, that up-to-date possibly didn't came, 10-9, he states, my lord. Can it be that updated, my lord, then kindly, my lord?
Update to 10-9.
10-9 is earlier, my lord.
10-9 is the earlier one. Earlier.
Not updated, my lord, not
No
updated,
change in investigation, last 10 days.
my lord.
Maybe.
Obliged,
You can always file.
my lord.
Can I come in, sir? Baba, come on.
Left.
It is not your lordship. Yes, 14.
Yes, there is what theft. Yes, there is not a issue, press requisition. This is the matter on. Don't give a very long bit because he's not on interim. Doing. So theft case, that's why that's important.
14.
14. And
It is a previous bail application, which you will find there, paragraph 13. The allegation, lordship, is that the informant's car was taken by one Rupam Soikia, lordship, on rent. Subsequently, that vehicle was found parked near my used car dealer, lordship. Actually, Rupam Soikia, he has kept it in my dealer, and he has sold it to one Mustafizu, and that was in my dealer shop. Subsequently, I have appeared in arrest because Rupam Sikhe is already arrested in this case.
So anyway, so that is,
The diary is-
what does it say about each law?
He's a proprietor of Bajrangi Motors. They had, and for a statement where made by my colleague, from Soikia, they took the car from rental basis. After that, what happened? He stopped the payment of the rent. The owner of the vehicle.
He had taken on hire,
Higher. They had
stop payment.
Stop payment. After that, after 2 or 3 months, he sold the car to various persons.
Various.
Yes, but lots of cars will take on rent. Okay. And he's on rental services. It's on the Rupam Soikia. And he is the co-associate of Rupam Soikia.
Co-associate.
Yes. So his one car is recovered from his in the house of his previous direction. So at least I think his custody is required.
No, no, that is, I and the respective court will
Because-
decide, but may be necessary,
Yes,
cannot be ruled out.
because the Rupam Soikia said that yes, his leading part was taken by this petitioner.
They may be pushing it,
That's it.
throwing to each other.
Each other.
It's not very reliable, but anyway, other materials are reliable,
Yes,
and the other materials are more relevant.
from the date of that incident, also he was suspending. So his custody will be famous required at this bit of investigation. That's it.
And that can be done even if my cooperativity investigation. Also.
Recovery may be necessary. For 482 application. Unbazar case, 273 of them. Include us. Case diary is called for April receipt. It's submitted by the prosecution. The present petitioner revealed by the investigation to be an associate of the main accused Rupam Soikia. However, Rupam Soikia in his statement has attributed the main role in the alleged offences to the present present petition. The alleged offences are in the nature of taking vehicles on hire and then selling to different persons illegally. Nevertheless, investigation is in progress. At this stage, the fine force in the contention of the prosecution that anticipatory bail might prejudice investigation. According to the bail petition stands removed. It is just returned back the case by 42.
May I please, your lordship, I have a small query, lordship. From personal difficulty of the arguing counsel, lordship, matter may be exempt for
Today. Just no diary as well.
Yes, these are cases of serious financial, cyber crime. Earlier rejected by your lordship. So people till now, 11 accused persons arrested. He is one of the most wanted accused. And from one of the accused, I have found that illegal transaction of more than 2 crore rupees in a period of 2 days.
Since interim is not there, allow it's fair.
Yes.
So, case diary and extensive investigation is received. However, learned counsel, a leading counsel stated to be having personal difficulty, and another day is prayed, another adjournment is prayed for. So, the case diary will be returned and procured again after updated investigation. List on
28 can.
okay, 28. No, it may be need for it. Yes, a little earlier.
17 can.
17, huh? 17.
May I please, your lordship? Lordship has already heard the matter on the motion day itself and declined to grant interim protection on the ground that the victim boy is only about 12 years of age. Now, lordship, what happened, lordship? He committed theft in our garage. We are the employees, and the 4 persons are named in the FIR, where 3 persons are already granted bail. I was a worker in that garage, and the owner of that garage, he has been granted bail after his arrest by this honorable High Court lordship, which is at page number 19 Annexa B. Dilnur Ali, he is the owner of that garage, and lordship, other 2 co-accused, they are granted anticipatory bail by the district and session judge, lordship, Dhemaji, Amingaon. Now, lordship, only remaining accused is me, lordship. Yes, lordship, they are granted bail, and I am Moinul Ali. Only I remain, but lordship, I am similarly putting on this with this other 2. I'll look into that.
Lordship,
Yes,
that is kept pending. Otherwise, the statement of the witness and the co-accused owner of the garage. That yes, they have on suspicion of theft.
They chased
the
him.
boy, chased him, and under fear and faith, he fled away. But later on, he was found by dead, like taking a blow. Causing a regret that, but near a dead.
Yeah, immediately or later, because that was, I think, found peculiar.
Peculiar.
If I remember, it seems they allege that it is immediately. That cannot be.
No,
That cannot.
Lordship,
there is another ground, lordship.
because he may have jumped before a train died. That's different. Immediately,
But
while being chased, possible. But hanging,
yes. But later on, he found. As for a statement of them, co-accused and other persons, when they just went out, they returned back. But
Lordship,
later on,
there-
he was found.
Lordship, I want to tell the real fact. He has no mother. The father married another lady. Thereafter, he is facing some trouble in his house, lordship. That may be the reason. And why a boy committed suicide? What was his mental
it's a
condition?
very unfortunate. story.
Yes, lordship. At this stage, we cannot know. We cannot determine why he has committed suicide and what was his mental condition at that time.
Okay, no problem. Others
Because
are
his mother is no there.
others are also granted bail. He can be.
Yes,
But should I dispose it off, or you want the report, opinion?
This not dispose it of.
PM report,
PM report is it's pending.
PM report is received.
No, received, but the opinion is pending for the update. But as per my humble submission, Lordship, because of he was subsequently when he was the hanging portion of it, that is not prepared in the case. The third part or subsequent back also.
Due to some learned addition of PP submits that no case diary is received. But including the PM report, but the opinion regarding that not yet been incorporated therein. And it is pending for FSL report.
Yes.
The victim is alleged to have committed suicide by hanging
Hanging.
after being chased, after being allegedly chased by the petitioners for theft. For alleged theft. The learned, Mr. Gogoi, learned counsel submits that three of the other co-accused persons, one co-accused person has been granted regular bail,
Regular bail, yes, from Honorable Guwahati High Court.
regular bail,
And other two are anticipatory.
regular bail by this court. So copy is produced. Two other accused, co-accused are stated to have been enlarged on anticipatory bail by the learned court. The case diary may be sent back and procured again with updated investigation, especially the opinion regarding death. In the meantime, considering the aspect of clarity, it is directed that in the event of arrest of the present petitioner in connection with this case, Kamalpur PS case number 82 of 25. He shall be allowed to go on bail of rupees 25,000 advance service. The satisfaction of arresting authority, and subject to the condition that he shall cooperate with the investigation and appear before the eye for examination. Tell your story before the eye, what happened, what actually happened.
All right, deeply organized.
Yeah, very unfortunate. 12-year boy is subject to it.
Unfortunate. So
Yes, no,
his
At the beginning, I have already said,
he has a good
very unfortunate.
next slide.
Deeply organized.
That's all what we can say now. You didn't take the date, list up to
2017.
2017.
Please, your lordship, I'm appearing for S. Nawaz. Lordship, CD has not yet come.
If I have made a prayer, Lordship, to for fiction other than.
Lordship, 14th October,
Your good name, please.
8th of that.
Learned counsel. Yes, for the petitioner to do. And for the leading counsel, S. Nawaz. The case diary is not yet received, not issue reminder.
14th.
Please start 1410. Interim is not there. What is the allegation?
There is no interim. Lordship.
118 is closed.
What's 118?
Previous. 109 was there.
Symptoms of allegations. List on 1410.
Much of lower.
Is a paying from the informant service.
You are applying for the information. Okay. Learned counsel. Much of the information. And you have only supplement.
My pleasure, Your Lordship. I'm on interim, Your Lordship. We have approached the IO twice, but he was not available at ES also.
Fine, I will record your submission. I'll record.
We have not received a case, right? We don't intend to accept a
Yes,
case.
I'll record. You can only appear. You can only appear before the IO. Recording is not in your hands, isn't it? That's all. Please submit your good name.
Our poor, Your Lordship.
Ask for our core learned counsel for the petition submits that. Pursuant to grant of interim pre-arrest bill on 8/9/25, the petitioners appeared before the IO. But they were not examined on two occasions.
Two
On
occasions,
two occasions,
he was not available.
but the IO was not available. Appeared before in the police station on two occasions. Appeared in the police station on two occasions, but the concerned IO was not available. Case diary not yet received. First recognition. Interim order passed on 8/9/25. Stand extended in the next date of list.
28/10/25.
Okay.
Like,
Yes, Mr. Bowler. That matter.
City was called for. I'm told that the city has an idea. Yes. This is an application for pre-arrest bail. In connection with this case, madam, two persons have been arrested, two persons have been arrested, and they have been allowed to go on bail. The FIR is at page 18. The gist of the FIR is that, my lord,
Just, you have been allowed to go on bail.
yes, after the arrest. My lord, the gist of the FIR is that, my lord, this is a finance company, private finance company, and they used to accept gold security. Then the persons who had misplaced the gold from the vault were seen in the CCTV, and there was one lady who had helped in converting this gold into cash and all. So they both have been arrested. So far, initially, my lord, the petitioner was, since he is the branch manager of the finance company, there is of course supervisory lapse on it. But since, my lord, I did not appear before the IO and had applied before this court for pre-arrest bail, they think that I am involved, and that's why on the basis of the co-accused statements, now they are looking for me also. But if your lordship looks into the page 26.
Very simple. In the forwarding, right?
Yes, madam. Your lordship will see a brief of the case. Then middle portion, your lordship will say, the said kept misapprehension was done by accused Moon Ahmed, branch head, and Kuldeep Dekar, assistant branch man. I am Moon Ahmed.
Yes.
Both the accused disappeared without notice to the company when the audit was undergoing in the branch. Further, during the audit, it was confirmed that no damage to the vault storeroom was occurred. As such, it is believed that it was opened by using the original key, which was kept in the joint position of both the. The simultaneous disappearance of both the employees along with unauthorized vault activity indicates the involvement of the accused committing abuse of their official position for personal gain and loss to the company. Therefore, the accused have committed criminal breach. Now, your lordship will see at page 28. Page 28, after the table, your lordship will find further on examination of the CCTV footage of Asirvad Microfinance Company, the Kerala branch, dated 30th of May, accused Kuldeep Dekar was seen taking out 2 gold packets from the vault room and concealing in his pockets of the pen worn by the accused Kuldeep Dekar. Access prime officer involvement of accused are found. So far, my lord, I have asked that why it's a 2 key, then why you have given the other key. He said that he used to do it, so out of trust only I gave it. That's supervisory lapse. And basically, this is the gist of the case. Of course, Balat, there are earlier occasion also there was strong objection from the PP because it is because it is amount is 74 lakhs and on. But your lordship, even in spite of that, considering the schedule list also, your lordship will find the condition. Your lordship will
Caesar list. The page.
But I have it's in the but for ready reference, your lordship will see. The goals were
Just a minute. Yeah.
first page, your lordship will omit. The second page, your lordship will find the packet of pledged gold was seized. Then second page also, your lordship will find the pledged gold were seized. These were the gold which were misappropriated and subsequently seized from the person whom it was entrusted.
Right.
So basically now it is no more those 74, all those seizure lists your lordship will find the golds. Basically your lordship must so far that 74,000 lakhs, I don't think that it is now 74 lakhs, but still it was a criminal breach of trust. And so far I am concerned, my lord, I had given this key to Kuldeep Deka out of good faith as an employee of the bank. But otherwise, nothing was recovered during my seizures. And now the police are after me because I don't have the anticipatory bail protection. That's
One of the two main accused obviously.
yes. I have annexed those bail orders also. Your lordship will find.
I'll go. CD has come. I'll pass today on. And need some time to study. You make your submissions.
Yes, regarding the other two accused persons, the other two accused persons granted bail only on the grounds of length of detention. Earlier, the bail petition of all those accused persons were initially rejected, mother. And now regarding the present accused,
Investigation is going on.
investigation is going on.
FIRs of 17 June.
Regarding the present accused, my lord, during co-accused my lord Kuldeep Deka, who was my lord granted bail on the ground of length of detention, my lord, who in fact, my lord, they are involved in, my lord, thereafter what they have by taking the goals, the original goals from their own financial institution, my lord, bank. They, my lord, handed over to, my lord, Riapol. Riapol is the, my lord, one of the, my lord, these gold appraiser of one IIFL company, my lord. Thereafter, my lord, by depositing
Gold appraisal.
yes, gold appraisal,
Value of gold.
appraisal, yes. Thereafter, what they have done, my lord, by handing over those, my lord, original gold to Riapol, my lord. Then thereafter, Riapol, my lord, company of the Riapol, my lord, issued bank loan to some other persons by taking those gold loans. And when, and in one case, I have found that some of the loans were taken in the name of the husband of the Riapol also. And when this, my lord, entire case, my lord, until the police lodge FIR, my lord, thereafter, my lord, as per his statements, he has, my lord, police recovered some of the goals from the house, from the father-in-law, house of the present Riapol. And regarding the present accused, during a short span of time, his salary is only 20,000. Is not only that, only the statement of the co-accused, the detailed bank statement of the present accused person is available in the city. Well, more than 32 lakhs of rupees, there is transaction well, in his bank account. His salary is only 20,000. Those, and total misappropriation as per allegation is more than 74 lakhs. So considering all these aspects regarding the granting of bail to other co-accused persons, only on the length of initially rejected, thereafter only see grants of length of detention, those accused persons are granted. So considering yes,
But I'll not. Yeah, of course, I have to pass the order today only.
Yes,
Because I have to uploaded also. But I'll just
the economic
go through it once, the chamber, and
yes,
it get the order.
with the economic offense when it considered.
But actual part you can take from connected data.
Main person was my lord, this accused and Riapol, from whom the recovery was also. Only the allegation against me is that my
Customer actually trust the whole business of the kind. Take care of the business. 163 of them. That's besides. Can I keep this for some time?
yes, yes.
No, I'll give it back.
No, your lordship can make it part of the record. We have extra copies.
We uploaded today on. I have to pass. That's why I have to finish. I have to complete.
Last day, my lord, everyone.
Yes. But I have to complete.
Obliged, your lordship.
That's.
Order.
What is that? Is it? Let's go.
Criminal appeal 302 of 2025. IA 856 of 2024. Item number 1.
Allow. We'll get the order today only. No, to be uploaded. It has to be uploaded today. Maybe tomorrow. Oh, no, tomorrow duty magistrate will be there. No problem. But today I think it will be late to go out, release. Yes. So otherwise certainly on Puja is over there. Hello. Duty magistrate is available in everything.
Delivery order, criminal appeal, criminal revision petition 4/14/35.
Petitions, issue notice and then is edit. And sentence suspended, allowed to go on board. That check is where you are undergoing 4 months out of 6 months. You can settle them. Just orders are there, so let's see what.
National site number 1, re-elections 3237.
New application, my lord, I have a small prayer, my lord, your lordship kindly see, my lord. Para
ABs are fixed on 1610.
yes, that I come to know, my lord. Para 11, your lordship kindly see. Para 11, my lord. Para 11, last part, page 21, kindly see, my lord.
Yes, yes.
Regarding on medical, my lordship kindly last but one of the 3 line, my lord. Para page 21, my lord. Moreover, has your lordship got it? Yes. Moreover, that the present accused petitioner himself is the patient of hypertension, chronic asthma, chronic symptoms, and having difficulty in breathing, the sweating, and fraudulently and frequently, and nebulizer solution and such solution. Since the consideration of period of time is together, further the accused petitioner after his arrest has been facing regular medical compensation and jail with a later medical checkup on 25. I have been told, my lord, he was been, my lord, examined. So may I submit that, my lord? I will take a chance because, my lord, your lordship kindly, my lord, fix it on, my lord, vacation bench, my lord, 8 or 9, my lord. And when in the meantime, medical report of this petitioner may be called for, my lord, along with the case there, because case there is all along here, my lord. Probably there is no improvement.
Yes, I will send back.
So by this time, it will be more than, my lord, month, my lord. So that's why I am submitting, my lord, if your lordship, my lord, fix it. Any vacation ban, sheet, my lord, learn and I'll take a chance, my lord. And along with the report of that day, my lord.
When was it rejected?
Rejected on, my lord, 24th, my lord.
24, only 2 days. Only 1 day. This file is 1 day. Medical, there should be a medical emergency to justify, because I also have my accountability. Because
chronic asthma patient, my lord. By this time, it will be, my lord, more than 34 days, my lord.
What do you say?
Send back the CD, anyway, we have to send back the CD also. Because investigation is still.
Yeah, CD has to be sent back. Already it was,
Because, my lord, the others, yes.
Do this. What are the medical documents submitted regarding?
Document I cannot submit, madam. There is a father's document I have submitted because already it is, he's inside the jail, madam. So that will be called by the authority, then, my lord, it will be here.
Let us see.
Can we fix on, my lord?
Let's see what can be done. Because no medical documents. Yes.
No,
Exam
medical,
can be directed to be even
no, medical document, my lord, on page 75, my lord. There is a certificate of no, this card. Yes, my lord.
Was this ground taken in the previous application?
That was taken, my lord, that is not reflected in the.
Okay, I'll check that again. Then
And my
pass
lord,
on.
another
You
important.
get it now. I'll upload it now. We'll get it uploaded.
And another important thing, my lord, what happened, my lord? The objection, I have seen the order, my lord. Objection filed by the, my lord, IO. I have not seen it. I cannot, my lord, reply it. But I have your lordship kindly see one aspect. I also miss it, my lord. That construction work is started up. The construction work of the drain was started in, my lord, 7th of July. And land was occupied. Land was, my lord, acquired in the month of February 2025. But there is a, my lord, in FI, it is stated that drains are open from last 1 year. And moreover, my lord, now heavily relied by the IO, that, my lord, there is incident of the earlier incident. Earlier incident is the negligence of the, my lord, labor. These, my lord, touched the wire. No, my lord, why I am submitting? I cannot reply that, my lord, because it was, I have not seen.
No, bail objections are not furnished to the accused.
Correct. No, but
Part of the CD.
Yes, part of the CD, but I am unable to verify because that was in that case, I was the company was the informant, my lord. Because negligence of the labor, he touched the, my lord, live wire who is passing by the nearby the,
No, you cannot be wrong. Rightly, wrongly, the order has been passed.
my lord. I am not on that, my lord. I am unable to reply.
Then necessary, there's still one higher court you can go if necessary.
No, my lord, that is problem is this, my lord, is now High Court, also, Supreme Court also closed, my lord. I am not on that, my lord. Because
that just 2 days after rejection, and then because
no, that's why I am submitting,
medical
my lord.
emergencies. No, the thing is that there should be some medical documents of his illness.
No, medical
Background of
emergency,
his illness.
how can I, my lord? I made a statement here. No, my
they-
lordship, kindly see that my statement, my lord, on 25/9. It was examined by the, my lord, yesterday. That is inside. How I cannot get it?
Because it's not convincing to me that there's no medical, the contention of medical illness is made. No documents are annexed. Then
No, how can I annex it inside, my lord? Then, my lord, your lordship, kindly see, my lord, page 75.
At the time of filing that.
Yes, my lord. That is page 75, my lord. Page 75, my lord.
A report will be called from the jail doctor, and the jail doctor will give a report. Anyway, we can call for that, but it can be after vacation.
No, he's a regular patient, my lord. That is, I have annexed page 75, my lord. He's a regular patient of asthma. Page certificate is Dr. Rajkumar Bhatia is there, my lord. Page 75, my lord.
This is the subsequent bail application. Because earlier we heard earlier bail petition was rejected by this court on 24/9/2025 after perusal of case that. The subsequent ground is that the petitioner is a patient of hypertension, chronic asthma, chronic sinusitis, having difficulty in breathing, with sweating, palpitation, including frequent use of nebulizer and under medical supervision. And it is also stated in the said para 11 that he is facing regular medical complications inside the central jail and also has also undergone regular checkups. However, no medical documents regarding the same has been annexed with the present petition, but regarding the health condition of his elderly father, aged 56 years, some documents have been annexed.
No, my lord, one document of 70 page 75, that is one document of my lord, that is I have annexed.
Except one document. Peruse my attention has been drawn to the document at page 75, the bail petition, where it is certified by the doctor that the present petitioner, this petitioner is present a petition is under his treatment for hypertension, chronic asthma, and that he consults intermittent for his care. Nevertheless, it is prayed by the learned council that the matter may be fixed on the vacation bench. The learned additional heard learned additional PP 3B was the case diary has already been directed to be sent back in this and other connected bail applications which have been disposed, which orders have been passed. The case diary may be procured again along with the updated investigation. Considering the health aspect, the materials available at the moment do not indicate a life-threatening do not seem to indicate a life-threatening emergency. Therefore, it is directed that the jail authorities shall provide suitable, appropriate treatment to the petitioner. So, to the petitioner, and to the jail doctor, if necessary, also have checkups in GMCH. And further, medical report of his examination before the jail doctor, as well as from GMCH, may be sent on the next date, along with the case there. Fix it after vacation. 15th, madam.
Develop.
No, it is, my lord. My lord, I for a modification of one bail condition, my lord. Lordship will find the order at page 8, my lord. I was granted bail on 18/3/2025. And my lord, bail conditions are at page 12, my lord. There are 9. And first condition, my lord.
Yeah, I don't, have this kind of condition.
Yeah, so final complaint has been filed in the matter. And they have, final complaint has been filed in this instant matter. And they have approached the lower court below lordship. And they are on their school also, they can approach before the trial court. You can
Lordship,
make
one-
an appropriate.
One submission, my lord. My lord, his brother, my lord, he was also arrested, my lord. He was granted bail and lordship was pleased to modify his conditions, my lord. In a similarly situated case, my lord. May I pass this order? ma'am?
Yeah,
This-
that's why I think I passed
Lord-
something.
Yes, ma'am. He's
I
granted only.
don't pass this kind of order. That's why it's, usually I don't impose this because it creates complications. Yeah, but it's my order. 11 need. Oh, where's the bail order?
Bail order page 8, my lord.
Page 8. Earlier, Nandi Madhu. That's why I was taking. This is my modification order. This was my, I allowed the modification.
Allowed the modification of his brother.
What
my
I
lord.
was thinking, I don't remember passing this kind of, this kind of, I'm not saying that, I don't remember imposing this territorial restriction condition. Court may be within its liberty, fully right also, we impose. But I don't remember passing in recent times, so I was looking at this thing. All those, Nandi madam had imposed restriction, no problem, she might have been justified, that must have been justified. But now you see, a modification of this.
Modification, my lord. Only that part, my lord.
Then you allow similar grounds. He is also a business.
Businessman, same, my lord, brothers, my lord.
Same brothers. He has to travel outside.
Travel outside.
And you must have stated that in the petition.
Yes, ma'am.
That should kindly record my submission.
Yes. Learned counsel.
KJ,
KJ appearing for
GST,
GST. GST. What is it called? The central GST.
central GST.
Central GST. Finance Ministry, Union Finance Ministry, basically. For the Ministry of Finance, Government of India. Submits that as the, it's called final complaint. Final complaint, which is actually equivalent to charge sheet.
Charge sheet.
You're not right. Final complaint has been submitted before the learned trial. Perhaps the petitioner applicant can approach the said learned court as well. But let me discuss it. Same identical order.
Only the case number is different, my lord. It
Case
is
number.
mentioned in the petition, paragraph 3.
Equal, so.
I agree.
Much of it.
May I please, your lordship. Also, for correction, your lordship, inadvertently in the order, it was written as Mukalmua PS. It ought to have been Moran PS. Lordship.
I feel very sorry to you when you have to correct these orders. We also have here, but we have to check no excuse for load. It delays the relief as people have. That got so many extra detention.
No, Lordship,
In case of such errors, quickly find it. At the moment you detect. Anyway, the applicant is seeking correction of error in the bail order dated 28/2025, passed in PA 2664 of 22. Stated that in in the earlier part, it was okay. But later,
in the para 8.
actually, they write from formats, that is the best.
Yes, yes.
So I'm getting, we need to check it. Para 7.
Para 8. Lordship.
Oh, it's. Para 8, instead of Moran PS case number 90.
Moran PS case number 52.
52, sorry, these are another cases. Moran case number 52 of 25, bold.
Under section 108 of BNS.
Salmo PS case number 90 of 2025 has been mentioned. 108 only.
Yes, Lord.
The same error appears to be a typographical error, and the same stands corrected. And the case number in para 8 shall be read as Moran PS case number 52 of 25 under 108 BNS. 23 bold. This order, the IA stands allowed and disposed of. This order shall be read together with the order dated 20 these passed in DA 2664.
Modification, I have for modification, my lord. Order dated, my lord. Annexure 1, page 10, my lord. Relevant portion is, my lord, 14, cross C, my lord. My lord, cross C, my lord. For modification.
Condition, para 14.
Page 14, my lord.
Conditions.
Condition C, my lord. My lord, he is a businessman here.
Same problem.
Yes, so he's outside the. He's a permanent resident of Borpeta, beyond the jurisdiction. And he has been suffering from here. English.
Structure. The applicant is agreed by bail condition number 6, 8, 6C. In the order dated 8/10/2018. So long.
So long. It's a APSC scam, my lord. So now it is pending before the special judge.
No problem. Can we allow? Motion.
Already he's regularly appearing before the court, my lord.
Actually, due to risk of abscondence discipline. Now it is in the state of trial.
It's the evidence statement.
Agreed by this condition to bail order dated 8/10/2018 passed by this court within bracket. Legal judges retired. In BA 2335 of 2000.
In BA number 2339, 2018.
2339.
2339, 2018. Well, page 12, my lord. Page 12 order, page 12, my lord.
8/10/2018.
8/10/2018.
Right.
In BA number.
BA number is not telling. BA number 2335 I'm getting.
2339, my lord.
Raju Saha.
No. Kamal Devnath. Page 12, my lord. Annexure 11. Election.
Connected with
Connect.
2339, 2339 of 2008. Applicants Komal Table. In the said condition, it was stipulated that he would not leave the territorial limits of city of Guwahati without written permission of the trial court and without informing the investigating agencies. The learned prosecution submits that the case is now at the stage of trial, right?
Right.
Before this learned special court. He is now
Businessman.
the applicant is now stated to be a businessman staying mainly in Barpeta.
Barpeta.
Allowing the application, the said condition C, 6C, is hereby deleted. What should I use? What should be used?
That cannot be deleted.
Modify will mean another condition. In my earlier order, I had written.
Yes, I have an earlier order.
Deleted.
Yes.
No, no. No, that condition is agreed.
That committee is agreed.
That he's agreed by that condition.
And one other is here, order is here. After hearing the direct counsel.
My order.
Not this is coordinate.
In the bail.
Modification.
What language has been used?
Yes, okay, I have made it. After hearing the direct counsel of both sides and considering the grounds cited in the petition, particularly the averments made in paragraph number 7 of the instant application, the prayer for modification is sought for by the accused applicant is allowed.
Modification in the bail condition.
Yes.
Yes.
Is hereby allowed.
Yes.
And
That is
another paragraph is here. Accordingly, the order that 11/2018 passed by bail applicant case number 18/90/2018 modified to the extent that the condition number P and E therein shall stand cancelled.
Oh.
This order shall form a part of order.
that is also another coordinate bench order.
Right, better. This according to the condition number 6C. The order dated so and so is hereby, what is?
Cancel.
Cancel, is cancel. Is cancel. This order shall be read together with the order dated 8/10. I stand disposed. All things also require so much.
High level.
49.
49.
Now, look at the case of Foxo.
Looks have got tired themselves. Correction.
All courts can prepare for the motion for the uses. No state vacancy 17. Earlier service was available.
I can, ask this. It will be better to hear him. Actually, this date of next test, next date of next day before the court, that 11 in November, next day. I wrote something.
The vacation will be happening. Now, I guess from the
This after the vacation on 28th. Happy with that.